even involved drinking and driving and a whole bunch of other stuff. So, but we don't know. We'll never know what the judge is going to protect the privacy of that juror. So we'll never know what that account was. Then the other issue was the Sally Port. Do you think the defense has a beef here?
Some of the things. Okay, the biggest thing, defense perspective, was that Michael Proctor said that he pulled the videos.
Yeah.
And watched them a long time ago. I mean, that is a little bit weird because that should have been in his file. It should have been, with everything that was given to Lally, and it wasn't.
Right.
I do think that's like the best part of his argument, but I think that he failed to really show how it's exculpatory. Like he kind of dismissed, oh, well, there's 8 a.m. video and it shows that it's cracked, not shattered. And the thing is, cracked and shattered is like not something that you can tell. Like if a window is broken, are you going to say it's cracked or shattered? It's just semantics. So like that whole thing where he kept saying that, it just seems so like weak. Because it's not something that somebody can know unless they saw it actually being broken, whether it broke or shattered or cracked. People are going to describe it different ways. So I don't think that part of the argument was really strong. I just think it should have been turned over for sure. But I don't see the prejudice because we already see other videos of her taillight with all the red pieces missing. So I don't know.
Right. That's the thing is it to what degree is it material? And if we just ignore the materiality of it for a moment, yes, it's very troubling that you have this. So the question is it skullduggery or is it inefficiency? Is there some problem with the way this evidence is being moved around and made available to the prosecution? And to decide whether it's skullduggery or whether it's inefficiency is to try to examine as to whether it's even relevant. Is it actually exculpatory, as you said? So I think Hank Brennan is going to really put on a powerful argument here that it was not exculpatory. In fact, that it was inculpatory. So, but we'll have to see what he says.
Yeah, for sure. I
So
mean, I
don't
just
know.
don't.
Go ahead.
I was just gonna say, it sounded like, so I was, not expecting, but I was like thinking that he was gonna, because he reviewed the videos. That's why he didn't make the argument till today. I was expecting that he was gonna say like something, like something was there that they were trying to like hide, and he didn't have anything. So,
Right. So everybody, this is Matt from Boundless Millennial. He's one of the OGs on this case that really saw through the charade going all the way back to the summer of 2023 and was one of the first people to see through it. And without any motive. He didn't have some hatred for Turtle Boy or he didn't have a connection to the families or the witnesses or the investigators. He just, looking through the evidence, initially thought maybe it looked suspicious, but on his own just kind of figured out eventually, no, this doesn't make sense. So did you hear what I said about the Turtle Boy new charges he's apparently picked up? This is what they're saying all over Twitter.
I have heard that. Do we know what witness they're talking about or anything? I know it's like another witness intimidation charge, but I don't know. It must be for a new witness or a different witness than the other ones.
It's a new charge, not necessarily a new witness.
Okay.
But a new charge. I don't know. I mean, I'm just going to go with what's being said on Twitter. So there's both a pro and anti Turtle Boy source reporting this. So let's just put it that way. So I don't think so the first person I saw it from was Dag Nabbit, who is, I wouldn't say pro Turtle Boy necessarily, but she is pro Karen, very strongly so. So,
Okay.
so I believe she has no incentive to want to put this out there and make something up. So, and I don't think she has a history of doing that. She's just really strong pro Karen. So, Casey Gates says, "Hey, Kevin and Matt. Kevin, as some sort of sensitive, I have a huge gut feeling she went back to the scene. Also, if we tell the truth, it will always stay the same, and a lie will change consistently." So, was that a factor in your flipping, Matt? The fact that her story seemed to be changing. Was it already changing back then in 2023?
I think it was before she did any interviews or anything when I was like, Hell no. And I think the main things were just like, I don't know, just reading, because the narrative that was put out was that it was like Jen McCabe Googled that. She like orchestrated the whole thing. And like he was killed inside the house. And when I first read the affidavit, it was really about just the amount of corroboration from all these other people. And that was like the main thing, like her niece waking up the niece and saying this and that. And just like the way that it was described, like I could tell from the descriptions of all the different people that she was like drunk and like having those drunken regret moments. And she was freaking out, realizing what she did. Because she was already hysterical before they even found the body, like screaming in the car, just acting erratic. And they were kind of just like, what the hell? And then she's saying, I hit him, I hit him, I hit him at the scene. And then I think the next thing that happened after that was, I think the father's interview was the first interview, right? Before she was shown.
Yeah, they did that interview in July with the parents. Yeah, I'm trying to remember if like it's on 2020 or something. I can't remember if Karen was in that interview too.
I think it was Ted Daniels, right?
Okay, all right.
And it was,
I don't remember, but yeah,
I think at that point I already knew.
So the one with the father talked about the hospital, right? Where he said when he went to the hospital, Karen said, "Dad, I backed into something."
Yeah, I was shocked by that. I was like, why the hell would he want to even say that? I was like shocked. I was like, I don't know. Everything that happened after I realized what was going on just supported my belief, like my changed mind. And I was disappointed because I wanted a conspiracy. Like I was bloodthirsty for conspiracies, just like everybody else. Yeah. But I mean, I can't just deny facts to make my dream come true of the conspiracy. And that's what people are doing here.
I know that's what's something that people don't understand when they try to say, Kevin, you're just grifting on this. It's like, I wasn't grifting when I was covering for the conspiracy side, because I was always going to cover the truth, and I was asking questions right along about whether it made sense. But it was in my interest to stay on that side. That crowd became very friendly to me, and I built a team around me, not just two co-hosts, but then also a team behind the scenes. They were all pro Karen Reed, and I enjoyed working with them, and so it would have been hugely beneficial for me to just stay on that side. But like you, I kept asking the questions, and then so what about the other question? The other part that she asked us was, what do you think about Karen? Do you think she returned to the scene of the crime, and how strong is that evidence if you do?
I mean, so to me, it makes more sense. Like someone said it recently, like that she would have driven back right away and saw him, and then she gets back and starts calling, saying nobody knows where you are. And that's where she started being like, oh, he's cheating on me. I left him at the bar. And that was going to be her story, not realizing that 7 people saw her car outside that house.
Right.
But the original affidavit was suggesting that she went back in the morning, which also could be true. Yeah. I don't know if they got more than what they had. I mean, they just had tower data in the first trial. Yep. But if they got more information from the Lexus text stream, which could be, because I haven't seen anything else. Like I think they might be getting more information from her phone, or they're trying to, but I don't think there's anything there because the defense didn't really like put up a fight about that. Right. So I wouldn't think that they have anything there, but the text stream maybe is going to prove it. I think that would be like paramount to proving that it was second-degree murder. If they can show that, but I don't know if that's something that they can prove beyond a reasonable doubt from what we know so far.
Right, and that's the key thing. You have to prove it beyond a reasonable doubt to 12 jurors, and it's not just enough to show that she drove down Fairview. You have to show that she saw John, which is a taller order. One thing that I've said is that Lucky could actually be a key witness for the prosecution in that, because even though he claims it was 3:30, he could be confused on times, and there was reason in his testimony to believe he was confused on times. But if he did see an SUV parked there with the lights out, now if you could make a juror believe that possibly was Karen, well, sitting there with the lights out, that's consciousness of guilt. So to me, that would go a long way towards. But like you said, I don't think My bet is that we're not going to find any evidence like that in the chip off. We're not seeing any signs of it from the way Karen's team is responding. So we'll just have to wait and trial to see.
Yep.
Any bombshells for you this morning?
I just feel like the judge was not kind of putting up with his shit as usual.
Yeah.
So I was like, oh, good. She's actually.
Yeah.
I don't think there was anything bombshell. I mean, I guess the biggest thing is probably Proctor said that he pulled the videos in that grand jury,
Yeah.
and then that wasn't turned over. And like, I feel like there was discovery delays and everything in the first trial.
Yeah.
I don't know. I just don't think the video is exculpatory, but it definitely like this is the best thing that they have going for them at this point because
Yeah.
everything else is so solid. But I mean, if jurors look at those videos at 8 a.m. and 5 a.m., are they really going to be like, I mean, I don't know. Like, what do you mean? There's no red pieces. So like, I don't understand. Like, what could he have planted? And I don't think
Right.
anyone believes that in the first jury anyway. So I don't know
Right.
why they're like trying to die on this hill. I mean, I guess they're trying to get it dismissed today, but I
Yeah.
mean,
Yeah.
it didn't seem like it was an argument that worked last time. So
Right. And you're trying to get it dismissed and then even if you don't get Judge Canoni to dismiss it, you're laying the groundwork for an appeal. And you never know. You get a sympathetic judge or something like that. So I'm going to do a little booting. Oh, it's not even on this. It's on somebody else's. I can't boot this person. All right. So I'm going to go have lunch, Matt. Do you want to
all
stay
right.
on and just talk to people or it's up to you?
I'll pop off because I gotta do some things, and I'll
Okay.
be listening when they get back, and I can pop on later if I'm around.
Okay. Thanks for being here, Matt. Always a pleasure. And we'll continue after lunch.
All right,
Thanks,
sounds good.
guys. So, hey, everybody, I hope you hold on a second. All right, so I have my other. It's still doing it. Hold on a second. The audio was on my other laptop, so it's going to create that echo for you. All right, so we have. All right, I'm going to briefly pull this onto the screen so you can see it. I brought it on before. So this is the new charge that Turtle Boy has picked up. Witness intimidation. He will be arraigned on March 18th. It's 18th. All right, looks like we're getting ready to go back in court too. So let me break that up. We have fan. So once we have fan, usually within a minute or two, we have court action. So we'll be getting back to it soon. But it's actually 6 minutes to 2. So maybe this is just a little fan teaser to get us going, and we'll start up at 2. So Turtle Boy is picking up another witness intimidation charge. He's due to be arraigned in Stoughton District Court on March 18th. He is appearing in this court in Dedham today at 2. So the question is will he be revoked? And I'm not a lawyer, but it seems to me that he will be revoked, and a very good chance that he will be sent back to jail. And my understanding is that so where last time he was sent to jail for 60 days, this time it'll be for 120 days. So Heather Ann is a lawyer, so thank you, Heather. Hopefully I've got that right. So yes, the new charge should lead to revoking a bond. Heather says not to meet the clients. I figured that, Heather. Although, I don't know, maybe during your MS-16 days or 13 or whatever that gang is. I'm kidding. So very good. So, I mean, is this intentional? These stupid new charges that he picked up. Is this because, so Turtle Boy didn't do a show last night. So we got yesterday in court this very important information that was given to the public, that the federal investigation is over, is closed. Turtle Boy normally does a Tuesday show. He doesn't do a Tuesday show last night to bring that very important information to his audience. Actually, now that I think about it, I think he did do a show last night. Someone told me he didn't, but I think I saw when I went to my YouTube that he was live, and he had a much smaller audience than normal. But I'm not sure. I'm going on memory. In any case, but is Turtle Boy now trying to go? So Frankie Figs, good to see you, man. He said he did. So is Turtle Boy trying to avoid being able to talk about this stuff that is embarrassing to him, really, in terms of the Karen Reed thing, like deliberately trying to get back to jail? I mean, it's something to think about, right? Because what is he going to do? More and more, Karen is being steamrolled here with more and more evidence that comes out that just completely debunks the conspiracy. Just looking to see why the ceiling fan is not moving. Making sure my screen isn't frozen? No, the ceiling fan is actually just off. I don't like to see the ceiling fan lifeless. That bothers me. But it's not freeze. Obviously, it's cold enough in court today that they didn't want to put the fan on. But if somebody could send a memo to them, please put the fan on. That's comforting to us to see the fan be alive. You don't see the fan. How is that possible? You don't see the fan. You're not seeing where it says coming up Karen Reed motions day 2. I'm seeing that on my screen. I don't understand. Let me reset, I guess. We're not missing anything. There's no hearing going right now, so I'm just going to reload. So I guess just reloading it did it. Huh. That's weird. Well, the imperfections of this technology. It's just me on screen. You still don't see the fan? What the hell is going on? I don't understand. Try a different way. All right, you see fan? I don't. It's really weird. You don't see me now. Can you see me and the fan and the fan? Oh, good. Thank you, Mama. I don't know. It was weird because on my screen it was showing the fan. Thank you, Lisa. All right. So I switched to a different computer. I don't. The other computer is showing it fine, so I don't really understand. Hmm. Well, that's why I try to keep multiple screens going in case something freezes on one where I can jump right over. Yes, Turtle was at CF McCarthy's last night. I don't know about the hillside. What do you mean everything is perfect except the fan? You see the fan, right? It's just not moving. Just making sure, Ashley. Okay, cool. So I don't know who's coming back on with me this afternoon. At some point, could be Matt, could be Jen, could be Kate. Hopefully, with an update. Could also be Daniel from Drunken Turkeys is live now on his own channel talking about some new information on the Idaho on the Brian Koberger case. No strays. Ent says, doesn't Turtle Boy have to be arraigned first on the new charge before a hearing and bail revocation? I don't know. Not being a lawyer, I don't know. Why is Bettero not with Turtle Boy? Well, the Turtle Boy hearing doesn't start till 2. So he's probably there now. I would. So that's a good point. I guess when we come back to the Karen Reed hearing, my guess is we won't see Bettero sitting with Karen's family. Heather, so the question there is, and you may have already answered it. Okay, we're getting movement on the fan. All right. So, but does Turtle Boy have to be arraigned first before you can charge him with violating his bond? Heather says that an arrest can be used to violate. Well, he wasn't arrested though, to my knowledge. I'm sorry, Big Bird. I didn't see it. Sorry. Okay, Jen. I didn't see the email yet. I will check that, and I won't play it now because the hearing looks like it's about to start anytime here, and I can't have both things on the screen. So we'll play it after.
Goes back in session. You may be seated.
You guys,
All right, Mr. Jackson, go ahead and continue.
Thank you, Your Honor. When we left off before lunch, we were discussing the inverted video. In the moving papers, the prosecution indicates that, quote, the prosecutor had not previously received this video or knew of its existence. This is I don't know, if it's the third or the fourth time that the Commonwealth sort of runs to this argument about not knowing personally about the existence of a particular video, but that it doesn't matter how many times they argue that point, it still doesn't change the fact that it prejudiced the defense by not having it, and one of their members, whoever that agent is of the Commonwealth, was lying about having it and not disclosing it. Somebody knew, and the question before the court is, who was it? Who did know? Perhaps it wasn't Mr. Lally. Perhaps it wasn't Ms. McLaughlin. Was it Chief Rafferty? Certainly Proctor had it. He watched it. Who else knew about it? Members of the prosecution knew of the existence of this and other videos, and they hid them. And that's the galling issue. Then the Commonwealth writes that the defense altered, their word, the defense, quote, altered evidence to correct the image, as if we were altering something to deceive the court. When in point of fact, the Commonwealth well knows that that altered video was altered by them in some way, shape, form, or fashion. When it was played inverted. What we did is recorrect it to the proper orientation to confront Sergeant Buchnick with it. They indicate that they played the entirety of the video, of the corrected video, to somehow suggest that the Commonwealth during this debacle had clean hands. And that's just not true. Over the course of 2 days, the court will recall 2 days worth of testimony. Day one with Sergeant Buchnick under direct examination by Mr. Lally, going into the next day, still under direct examination by Mr. Lally. They played that video completely inverted. They talked about it, they discussed it, they described it. Not once did Sergeant Buchanan or Mr. Lally inform the jurors or the court that the video was actually altered, that the video was actually backward not one hint to the court or the jury members. When the defense stood up and began questioning Sergeant Buchanan about that video, that was the first time that he admitted that it was inverted. He used the phrase mirror image, and that he knew that it was inverted. Amazingly, that was the same time that Sergeant Buchanan started having trouble with his memory about who was actually depicted in that video. The court will recall before I stood up on cross-examination, under direct examination by Mr. Lally, Sergeant Buchanan was very quick to point out that the individuals on that inverted video were himself and Michael Proctor. And they made the point that Michael Proctor never approached or had any access to or didn't manipulate in some way, shape, form, or fashion. This was the intimation by the Commonwealth, that passenger taillight. The Commonwealth has now conceded that that person was, in fact, Michael Proctor. It's notable that the Commonwealth went to great lengths to state that, quote, Trooper Proctor, and this is in their opposition, Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight, end quote. That's a statement made in their moving papers, specifically on a fact that is of great material importance to this case. The three of them signed, the three prosecutors signed an oath and a declaration, and the court just called the defense out on signing a declaration or an oath. And the court's intimation, at least in its initial comments to me, was, you may have said something that you don't have a factual foundation for. I think I have done my best to disabuse the court of that we were drawing from reasonable inferences. I wonder if the Commonwealth is going to get the same treatment for saying that Trooper Proctor was standing feet away from the defendant's vehicle and never touched the right rear taillight. That's a very bold statement for the Commonwealth to make, and it's also completely untrue. It's not supported by a single fact. It's not supported by a fact or evidence before the court. The problem with this unsupported motion, because it's unsupported and the declaration is signed by three different individuals, you can just sort of say whatever you want in the motion. And I guess get away with it. The video speaks for itself, Your Honor. It shows Michael Proctor walk behind the car directly to the position of the passenger taillight. He positions himself right on the other side of the camera view, not feet away. And it certainly does not show, and there's no evidence before the court that he, quote, never touched it. As a matter of fact, we would submit.
Does it show that he does touch it?
Well, of course it doesn't show he touches it, Your Honor. It's he's on the other side of the car. That's not the point. The point is a reasonable inference is he could have touched it. He was standing right there. Nobody forced him. Nobody was holding a gun to his head. He walked around the other side of the car and obviously was standing there for a reason. By himself, in a corner, out of the view of a camera, and then when the Commonwealth plays the video, it switched, and the intimation to the triers of fact was he never approached the right rear taillight, that passenger taillight. And all of that
And
was
you
unclear.
cleared that up.
Right. But that is the galling part of this entire thing. The court has asked me a couple of times, and I'm going to get to it a little bit more in detail, what the prejudice is. If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact. That is not a small thing. Even after the trial was over, it was concluded, and the mistrial was declared, we're still getting videos that we can't get a straight answer about their source. Where did these videos come from in October? That surveillance feed is on a 30-day deletion loop. That's what we've been told. I said a few minutes ago this morning, I said the Commonwealth may not have known that it was on a 30-day loop. What I meant was actually the prosecutor sitting in this courtroom. The three, my brothers and sister, may not have known about that 30-day override. I don't know. I don't know what they knew or didn't know. I'm certainly not going to cast aspersions and put that on them. But someone from the Commonwealth darn sure knew that was on a 30-day loop or a 30-day override. So who's had those for all this time? How were they stored? Why wasn't that information revealed to our expert when we went all the way to Canton to try to download that DVR? Where's the original? Where are the copies? These are questions for which we need some facts. And the fact that those have been withheld from us is exactly the kind of bad act and bad faith that demands that the court presume prejudice in the case. A few minutes ago, the court asked me before lunch, what is the prejudice? There's plenty of actual prejudice, but I'll get to that in just a second when I speak a little bit about the law at the end of my comments. We don't need to prove actual prejudice because the law presumes prejudice against Ms. Reed because of the bad conduct on behalf of the Commonwealth. And yet again, when it comes to this same issue, the Commonwealth recites this now worn out sentence, the prosecutor was unaware of the existence of these videos, end quote. How many times are they going to try to excuse away a blatant discovery and or Brady violation with the sentence that the prosecutor was unaware? It just doesn't matter. And that brings us to the October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter. And it actually wasn't a letter, it was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering, end quote. LOL, laugh out loud. So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations and
what was the
discovery
date?
violations.
10/10/24 you received that? Was that the date?
10/10/24. That's correct. By the way, the Commonwealth claimed in its opposition papers that, quote, the prosecutor requested that both Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video, end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, all relevant and material surveillance video. So why didn't we get this from Canton PD until October 2024, well after trial? What was the delay? And why did we get another video in January of 2025? What was the delay? How could this be seen as anything other than intentional? We know now that Sergeant Buchanan, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, DGM Petro, all had access to and knew about the videos. And then we have on top of that, in the middle of trial, I think it was Mr. Lally, it may have been Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant and material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday, this past Friday. Additional reports from the Commonwealth, in a report from Sergeant DGM Petro, he reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested Sallyport video of SUV inside Sallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested Sallyport video of the SUV exterior footage that he downloaded it from somewhere and gave it to him. Assuming it was February of 2022, that would have been before the override, I presume, because I think the math in my head is it's 28 days in February. If it's in February at all, it's within the 30 days from January 29th. So it has to have been. Then he writes that in June of 2023, Proctor requested Sallyport video again of the SUV exterior footage. Quote, this is from his report, I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station, end quote. He goes on to say, quote, due to the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting. This is the first we're hearing of any of this last Thursday. How is that? Sure. Ms. Lewis just handed me a clean copy of the DGM Petro report. I would like to have this marked and appended to our motion to dismiss if it's okay.
Sure. Did I get that attached to your motion to change the scheduling?
You,
You
yes.
probably did.
So I've seen it.
Okay. May I approach?
Hold on. What, Ms. Little?
We'd still like to make it part of the record if that's
Sure.
all right, Your Honor.
I just wanted to know whether I needed a copy because I have a copy. I've seen it.
May I approach?
Yes.
Okay.
So are we marking it? So we need it if we're marking it.
Oh, I'm sorry. My mistake.
Exhibit 1, so marked.
Okay. Go ahead, Mr. Jackson.
Thank you, Your Honor. The question is, how in June of 2023, now I'm going to go a little bit slow here just because it's linear. The argument is linear. In June of 2023, according to DGM Petro, he downloaded every single bit of video of that car while in the Sallyport or while at Canton PD in Sallyport. How is that possible? How could that be? As of February 28th or maybe March 1st, those videos are gone. So how could he have access to the whole thing? It's because someone at the Commonwealth downloaded the whole thing. They saved it. Or the only other explanation is that DVR was not at the time on a 30-day override. It's the only two explanations. Again, this is binary. So in April of 2024, as the court knows, we got additional video, and that's the inverted video. In the spring of 2024, while trial was being held, DGM Petro, quote, it says, quote, I downloaded some video recordings that you and I believed may be needed to refute claims being made by the defense. The you and I is him to Chief Rafferty. That's who this report is to. And it includes footage of Higgins. So now we find out for the first time that Chief Rafferty and this sergeant had been talking and strategizing about how to defeat some defense arguments, presumably, by use of videos that had never been turned over. And the Commonwealth uses a phrase in its moving papers, I believe in this motion, about ambush. That is the definition of an ambush. So DGM Petro admits that he, Rafferty, and the Canton Police Department had Sallyport video that was material to the case. Remember, his quote was that you and I believed may be needed to refute claims made by the defense. They were strategizing about how to defeat certain of our arguments, and they didn't turn it over. Specifically, he downloaded video and presumably gave it to Chief Rafferty. But then the interesting thing is Chief Rafferty held on to it. She never turned it over. probably because they didn't help the prosecution. They showed Higgins engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows him on the phone. And he testified that he didn't make calls in the middle of the night. There's no question that with this example, that is an intentional withholding of evidence. That is the legal definition of bad faith, and it's unconscionable to do that. Now put in context what we eventually did receive during the trial and then after. We received the inverted video that was falsely presented as the right passenger side of the vehicle, or the passenger rear side of the vehicle. Number two, we received several videos of Brian Higgins at Canton Police Department, clearly using his phone at approximately 1:35 or so a.m. And we received exterior footage that would ordinarily show the condition of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. It's not like the Canton Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite. Multiple officers, Proctor, Rafferty, Buchnick, O'Rourke, DG and Petro, these individuals, we believe, O'Rourke may not have known, but we know that the others did, and it had now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, they downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks. All of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We had no idea this footage existed, and to this day, it continues to be, the bulk of it continues to be withheld from the defense. And then we move to Sergeant Buchnick's actual report. As I indicated, he wrote a report last Friday as well, dated the 28th. Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2022, I was made aware that a request had been made by Trooper Proctor and then fulfilled by Canton PD for surveillance video as it related to the arrival and storage of the Lexus SUV belonging to Karen Reed. This was the spring of 2022, he knew. At Trooper Proctor's request, I proceeded to Canton Police and picked up the digital media storage containing said video and transported it to the Canton, Norfolk District Attorney's Office and turned it over to Trooper Proctor. I did not review this video at this time.
What date did he do that? The same date?
He says at this time, but it's the sometime early spring of 2022. That's the best he can do in his report. Paragraph 2, in July of 2023, so this is a little more defined, I was once again made aware by Trooper Proctor that a request had been made to Canton PD for additional video and that it was ready to be picked up. Since the Canton Police Department is conveniently located on my route of travel to work, I stopped by and picked up the CD from the front desk of the police department, which was labeled Trooper Buchnick with a yellow Post-it note. I further added Canton PD 12922, and then the case number, which is, or their case number, 2022-112-33, to note to more accurately identify the item and transported it to our office, subsequently turning it over to Trooper Proctor. So there's a second CD, now in July of 2023. I did not review that video at that time. See the attached copy of the Post-it note. Final paragraph, in my preparation for trial in May of 2024, I was provided with a thumb drive and the CD labeled with a Post-it note on my desk. What's interesting is that the CD with the Post-it note on his desk may or may not have been the same CD that he transported in July of 23 because they seem to be labeled a little different.
So I haven't seen this report. Does he say from whom he received that?
I'll finish reading it, but I don't believe he does. No, it's pretty vague. It's passive voice and it's pretty vague. I was provided a thumb drive and a CD labeled with a Post-it on my desk to review prior to testimony. So it does not say. At this time, I reviewed video made available to me, which included video footage of the Canton PD exterior Sally Port. Exterior Sally Port. This video was labeled with a Post-it note on a CD, and it contained a video of the interior of the Sally Port, which was grainy and had a camera vantage point from the front of the Sally Port. I also reviewed the Canton PD driveway footage. In review, I also viewed video of the back wall Sally Port camera vantage point. I had not seen this video prior to my May date review. I later learned that this video was provided in an inverted manner. After I reviewed all the provided video, the thumb drive and the CD were returned. It doesn't say to whom they were returned. Your Honor, if I could mark this report as well.
Sure. Do you have an extra copy for me?
I do. It does have one highlight on it. May I show it to Mr. Brennan?
Yes.
Are there two so marked?
So you do have an extra copy, Ms. Little?
I do not have an extra copy, Your Honor.
I thought Mr. Jackson just said he had an extra.
Oh, I'm sorry.
Yeah. Mr. Jackson, do you have an extra copy?
I think I might.
I've got it right here.
You have an extra copy? Is that one clean?
Not clean.
No, that was the only copy that I got.
May I approach, Your Honor?
Please.
This one has highlights on it. I apologize.
It's okay. Thank you. All right, go ahead.
Thank you, Your Honor. The court asked probably the most important question about this report, which is who was it that supplied the video or the thumb drives or the CDs to Sergeant Buchanan? Who's at the center of all these Sally Port videos? Who does he say was requesting the Sally Port videos that he was acting as the courier for in other particulars? Every one of those answers is Michael Proctor. So who do we believe most reasonably would have supplied the information to Sergeant Buchanan to review? It stands to reason, could have been Trooper Proctor. Seems to be reasonable, but I don't know because Trooper Buchanan doesn't say, but that would be another question that would be open to answer if we had an evidentiary hearing. Michael Proctor was receiving the footage directly from DG and Petro, dating all the way back to February of 2022. He was the one receiving the footage directly from Buchanan, dating all the way back to the spring of 2022. Michael Proctor was receiving footage from both sources multiple times through the years. Proctor was the one who clearly had possession, custody, and control over the exculpatory footage. It was his, every bit of it. And now let's recall what he said at trial when asked about all this footage, because he was confronted about footage. And keep in mind, Your Honor, when I'm asking these questions, I know none of this. None of it. Michael Proctor lied during his testimony, but he knew that we couldn't impeach him. There was no way I could impeach him. I didn't have any of these videos to impeach him with because we didn't have any of the evidence that had been secured concerning that Sally Port. Question: there's surveillance video from Canton Police Department Sally Port garage that wasn't turned over, right? Answer: that video was discovered later on and then handed over. That video was discovered later on.
So where in the transcript is that?
I can get you the page and line number, Your Honor.
My guess is Ms. Little can get it pretty quickly.
I'm
I'll
guessing she
provide that to you
can.
in just a moment, Your Honor.
June 10th?
It was either June 10th or June 12th, but let me double check.
While she's looking for that, Your Honor, may I
Please go
proceed?
ahead, yep.
Okay. The only thing it's important to remember from a date standpoint, we'll get the date that he actually testified to this, but from a date standpoint, the only thing that had been handed over at the time that he testified to that was a single video with 42 minutes missing and a flatbed and the flatbed driveway footage outside the Sally Port that doesn't show much of anything. It's now been proven, that testimony, that video was discovered later on and then handed over, suggesting there was either only one video or all of it was discovered later and turned over. Both of the clauses in that sentence are a lie. The video wasn't discovered later. It was discovered in February, at the latest, February of 2022, just days after this incident. He asked for it and he received it, according to Sergeant DGM Petro. And it wasn't turned over either. None of it. But at trial, we didn't have the truth. I couldn't impeach him with this. He made sure that all the footage was delivered directly to him, starting days after this incident. And he controlled it, he hid it, and then he lied about it. That is the definition of bad faith. That is the definition of withholding exculpatory evidence. That is a definition of suppressing Brady evidence. There is no other way to define this. He fooled us, and it's egregious. Is it possible, with all this sort of years-long flurry that we've just talked about surrounding these Sally Port videos, that the actual trial prosecutors were completely unaware of their existence until Proctor testified before the federal grand jury? Is that possible? I suppose it is. I want to give the prosecutors the benefit of the doubt. I do. Is it reasonable? That's another question. To believe that they just knew nothing about this. We know Proctor lied to us. Could he have lied to them? I suppose. But as the law mandates, Your Honor, it just doesn't matter. In the eyes of the law, Proctor is the prosecution, and the prosecution is Michael Proctor. And then we move to January 28th, 2025, this year. We're still getting additional videos at that time. This new camera angle, which is blurry and grainy and wobbly, it does, however, show the passenger side rear taillight as it's towed into or driven into the Sally Port garage. The footage is so grainy and so blurry, however, it's so corrupted that once again, the true condition of that taillight is completely obscured. At a certain point, it begins to defy logic. And the reason I wanted to talk about each one of these videos in turn is because it absolutely defies logic that all of this footage magically cuts out, blurs out, becomes grainy, becomes obscured at the precise time that the SUV is pulled in to the Sally Port. The question then becomes, what's been happening to these videos that have been in Michael Proctor's possession since that time, for the last 2.5, 3 years? And again, I've lost count how many times the Commonwealth makes the claim, quote, prosecutors had never seen this video, end quote. The entirety of the Commonwealth's defense on this issue is the indefensible, which is, it just wasn't me. Okay, fine, it may not have been you, but it was the Commonwealth, in quotation marks, capital. The Commonwealth then claims that, quote, after directing a review of all physical evidence and data files, after directing a review of all physical evidence and data files, this video was located within a paper case file of the investigators, end quote. I believe that Mr. Brennan, when he came on the case, he's the one who directed a review of all physical evidence and data files. I would have to guess. Again, I would applaud that. Should have happened years ago. What's most curious about this video, however, is that the prosecution now admits, quote, after inquiry, it was learned that an investigator obtained this video from Canton Police Department in 2022, and it was placed in a physical case file, end quote. That's a direct quote from their opposition. They don't name who the investigator is. They don't indicate whose case file it was. They don't tell us where that case file had been, who had control over that case file, just a paper case file somewhere, mysteriously. Whether it was CPD or MSP, we don't know. Which investigator, we still don't know. What can we learn from the submission by the Commonwealth? That investigators did, in fact, download the Canton PD videos in 2022 before they were overwritten. That's the only way these videos could exist. We've talked about that. And what we don't know is where the rest of them went and why we don't have them and why we didn't have them for the first trial. The Commonwealth basically concedes that it is in direct violation of its discovery obligations not to have turned over these videos that were in their possession. But it makes the claim that it doesn't matter because, quote, the poor quality of the video makes it difficult for either party to benefit from the video, end quote. In its opposition, it sounds like more of a desperate argument than anything else that these cumulative, that these egregious errors don't justify the court taking any action because they claim, quote, there's no evidence of bad faith. I would take issue with that. But the quote goes on, there's no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video. Equally aggrieved. First, in that sentence, the Commonwealth admits that the defense is aggrieved. They say they're equally aggrieved, however. Aggrieved means wronged or unfairly treated or suffered harm or injustice. Merriam-Webster defines aggrieved as suffering from an infringement or a denial of legal rights. You bet we're aggrieved. But the Commonwealth can't claim that they're aggrieved when they're the ones doing the aggrieving. It doesn't work that way. The Commonwealth concedes that there's irreparable harm. They acknowledge that the forensic videos were destroyed, or at least they claim now that they're destroyed. We can never obtain the information necessary to establish the validity of any of these videos or whether and by whom they may have been manipulated, if at all. The Commonwealth can't shift the blame because the videos have literally been in their possession the entire time. It was their actions and the actions of their agents that caused this irremediable harm. Your Honor, this is, as I said, this is the definition of bad faith. And this goes back to the court's original question this morning, which is, can you describe the prejudice that Ms. Reed has suffered? And I think we've done a pretty good job of describing that throughout this argument. But the definition of bad faith means we don't have to prove actual prejudice. Prejudice is presumed under the law. If we're to believe the declarations that were submitted by ADA Lally and ADA McLaughlin and ADA Brennan, then at the very least, there is no other conclusion but that Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, and they withheld the evidence from the prosecution team. Let's take them at their word. Even after being explicitly instructed to turn over that evidence, that is bad faith. And how many times do they have to say, we didn't know about this? It just doesn't matter. Like I said, let's take them at their word. It doesn't absolve the Commonwealth of its obligations, and it doesn't reduce the prejudice that the defense has suffered. This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know through this new revelation that it was intentional. The prejudice the defense has suffered is legally presumed, and it's also factually proven. And thus the only remedy is dismissal. When is dismissal warranted? And this is, I'd like to talk for just a couple of seconds about the legal standards. Where there's misconduct that's so egregious, deliberate, and intentional, prejudice is to be presumed. That means that the defense is not required to show Ms. Reed suffered any actual prejudice because dismissal is necessary to prevent the repetition of this type of misconduct. And that comes to us directly from Bridgman versus District Attorney for Suffolk District at 476 Mass 298. It's a 2017 case. Even if the court does not, and this is secondary to that, even if the court does not presume the prejudice and finds that these myriad violations were somehow inadvertent or a mistake, the result of some accident or negligence, this case still has to be dismissed under the second scenario and the second prong because Ms. Reed has suffered actual prejudice by the Commonwealth's violations. We could not cross-examine these witnesses the way they should have been cross-examined at the first trial. The repeated and flagrant discovery violations were not an accident. I think we've established that at this point. They weren't a mistake. There were too many people looking at them, strategizing about them, to then say, I didn't realize their import. They were designed specifically, the fact that we weren't provided the evidence was designed specifically to obtain a strategic advantage over the defense and to get a conviction at all costs rather than to pursue the truth. There are obviously additional Brady violations and prejudices that Ms. Reed has suffered. I've detailed those in our moving papers. And I want to incorporate all of those arguments by reference here as well. But relating to the surveillance footage itself, there's no question that the Commonwealth intentionally withheld it, and they've been withholding it since January 29th, 2022. The Commonwealth can't really seriously claim, Your Honor, that 4 or 5 or however many different law enforcement officers were aware of and withheld the surveillance video or the surveillance footage, and who were supposedly specifically instructed by Adam Lally or his team back in April of 2024 to turn everything over, and it was just inadvertently withheld. This was intentional. And the Commonwealth then compounded those violations by Michael Proctor lying on the stand about his knowledge of the video footage and his turning it over to the defense. It was literally a fraud on the jury. And now, well after trial, the Commonwealth has been forced to admit that even more exculpatory evidence or surveillance evidence from January 2022 is in their possession. And it was also entirely withheld from the defense throughout this litigation and throughout the first trial. In addition to the presumptive prejudice, Your Honor, there has been actual prejudice. This was, some would say, a close case when it ended. The court recalls that. The jury was hung on some charge or charges, and the evidence suggests that they voted in her favor on others. The court needs to ask itself, what would the jury have done had they had all the evidence to which they were entitled, to which we were entitled? But they didn't. Every one of these videos was in some way compromised, even the videos that we did have. And the compromise always conveniently obscured the truth and obscured Ms. Reed's rights. This is an exculpatory fact that we should have been able to explore during the past 3 years, and certainly we should have been able to explore it at trial, but we did not have the videos. The Commonwealth did, though, and it's the cumulative effect of all these gross and repeated violations that undermines the Commonwealth's argument that this is just about a broken camera. It couldn't be further from the truth. We're to believe that all these cameras just spontaneously became defective at the exact same time. Like I said before, it defies logic. For the Commonwealth to have all this footage for a solid 3 years and hold it back from us the entire time, it makes one question what was going on with that evidence. And I have to say, in terms of lesser remedies, Your Honor, what's interesting is that the exclusion, obviously the exclusionary rule exists.
I understand that does not help the defense.
It doesn't help the defense. And I appreciate the court finishing my thought on that. It's the opposite. The only remedy that can prevent this kind of repetition, this kind of misconduct, is dismissal. That's the only remedy available. And that's what the law, and that's what justice demands. As a final thought, if the court, even in the face of all this overwhelming evidence of gross misconduct, declines to dismiss this case at this time, we would urge the court to grant us an evidentiary hearing so that we can make an actual factual record of the myriad of issues brought up here. This will give the court a much better understanding of the facts supporting dismissal, and it'll perfect the record on these critical constitutional issues. And with that, I'll submit.
Okay, so thank you. I have a question for you. So go back to the podium, please, because you may need your notes. But Ms. Little, did you find the Proctor testimony?
I did, Your Honor. It's June 12th, 2025, the reporter's transcript at 1-148. And that's from the copy of transcripts with sidebars, just
Okay.
for the court's reference, lines 8 through 12.
Great.
Thank you.
I have a question, Mr. Jackson, just about, so you argued obviously the importance of the Lexus arriving at the Canton Police Department. You argued a distinction between a cracked taillight versus a shattered taillight.
Correct.
In your pleadings, and again, you just saw, I want specifics where I can find something. On page 28, you talked at the top line, cracked, not shattered, when it arrived at the conflicted CPD on January 29, 2022. If the taillight was largely intact and only cracked rather than shattered and missing 47 pieces, as Dighton Police Officer Sergeant Barrows testified he observed earlier that day, after the Commonwealth claimed Ms. Reed had struck Mr. O'Keefe, the evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth. The 47 pieces I'm having trouble finding. I just took a quick review of Sergeant Barrows' testimony yesterday upon being prepared for this. I didn't see it in there. Ms. Little, do you know where that 47 pieces is?
Yeah, the 47 pieces is not related to Sergeant Barrows' testimony.
Well, it sounds it from this, so I'm not to
No.
read it this way.
What Sergeant Barrows clearly testified to was that he observed a taillight that was cracked and not broken.
Okay, the 47 pieces, I read that to mean it was from Barrows' testimony.
No.
As Dighton Police Barrows testified. All right, where do I find that 47 pieces?
The 47 pieces, I can get multiple transcript sites, but those were the photographs the Commonwealth presented at trial, that there were that many pieces found at the crime scene.
It's the number of
Taillight.
pieces that were booked into evidence.
Okay.
Yeah.
Great. Yeah, if you have trial transcript of that, I don't need 47 points, but if there's something that summarizes it, because I took that to read as I see it reading.
No, Sergeant Barrows specifically testified about his observations of the taillight earlier that day.
Right.
It was uncontroverted that there were 47 pieces of taillight
Okay.
recovered at the scene.
That's not clear to me the way this is written, so I'm glad I asked you. Okay. All right, so with that, now, Mr. Iannetti, I'm not going to hear from you now about the court officers not being in charge of the jury. I'm going to hear from Mr. Brennan, and then we'll get to you, and hopefully we'll have time. But Mr. Brennan, I have a question for you. As I started with a question for the defense, so I'd like you to explain to the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the Sally Port videos, and why the dribs and drabs of the way the discovery came in.
It may be most helpful if I give the court a history as I've learned it about the production of video in this case,
Okay?
and it will explain in context the production of video and will help create the foundation so the court can understand, and perhaps the defense can best understand.
All right, and just like I did with Mr. Jackson, if I need to, I'm going to interrupt you
Of course.
to clarify some of this. So know that that's what I'm focused on.
I understand clearly. In November of 2024, has asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Sallyport area. There was nothing about it that was particularly relevant to them. The defense theory did not make it clear to them that that was important. There was no motion filed by the defense.
At what point in time?
This is leading up to trial.
Okay.
At that point, there had been no request by the defense for video of the Sallyport area. What I learned is that Trooper Proctor had requested Sallyport video from the Canton Police Department. And the person who was the custodian of Canton Police Video, who would download it from the DVR, was Sergeant D.G.M. Petro. He made a request shortly after this event on January 29th, 2022. Sergeant D.G.M. Petro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor. Trooper Buchanan did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not provide it to the prosecutors. So Trooper Proctor was aware of the video. The prosecutors were not aware of the video. That video is the same video that Sergeant D.G.M. Petro says that he downloaded the video in 6-hour segments, and that contained the front wall blurry camera inside the Sallyport and camera in front of the police station. That remained with Trooper Proctor for some time. In June, around June of 2023, Trooper Proctor then made a second request from Sergeant D.G.M. Petro
Even though we already had it?
for different cameras. He wanted cameras, a camera angle of outside the Sallyport area. So when the tow truck dropped the car off, leading into the Sallyport, which is now characterized as the exterior Sallyport video. Again, Trooper Proctor asked Trooper Buchanan to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Buchanan went to the police department, picked up the CD at the front desk. That CD had a yellow sticky tab on it with Trooper Buchanan's name, and Trooper Buchanan wrote in the case file on that yellow sticky. He brought the CD to Trooper Proctor. Again, Trooper Proctor in June 2023 had a copy of the exterior Sallyport video, but did not provide it to the prosecutors. Both of those videos remained dormant. When Trooper Proctor was called to the federal grand jury, essentially he testified or was asked about video and said that he reviewed video. Now, this was not evidence that the Commonwealth intended on introducing or had any specific interest in. There was no particular discovery request by the defense, and there was no order. But upon reading that grand jury testimony, ADA Lally reports that he then inquired about the video. This is
Inquired of whom?
Trooper Proctor.
Okay.
This is shortly before trial. ADA Lally was given a copy of one of two of those productions. He was given the copy of the front wall video, which also contained video of outside the front of the police station. That was quickly turned over after Attorney Lally received it on April 4th, 2022. So what we know at this point is Trooper Proctor has this original production on April 4th, 2022, shortly after January 29th, 2022. I'm sorry, it was provided April 4th, 2022.
2022 or later?
No,
It was later, right?
was
Because
later.
the
It was-
federal grand jury was later.
he provided it on the eve of trial. So it was April 4th, 2024. So we know this production on April 4th, 2024 was in the hands of Trooper Proctor in shortly after January 29th, 2022. At this point, the prosecution team is still unaware of the June 23 production, which has Trooper Buchanan's name on it, which shows the exterior Sallyport. As trial began, there still was no specific order or request. The chief of police saw something about the trial, and let me rephrase. Prior to the trial, it's reported that Attorney Yannetti was discontent because the video of the front camera sally port was so grainy, intermittent, and not continuous. And that's an accurate description of that video. Chief Rafferty, in response to seeing Attorney Yannetti's concerns, then asked Sergeant D.G.M. Petro to see if there was another camera or to produce any other video from the sally port. Sergeant D.G.M. Petro then downloaded video from the DVR, which is the second camera that is inside the sally port, known as the inverted camera, or now characterized as the inverted camera. That was produced April 23rd, 2024, given to ADA Lally, then given to the defense. And so at that point, there are 3 video productions that exist. The first turned over to the defense April 4th, 2024, the second April 23rd, 2024, and the June 23 production of the exterior sally port has still not been turned over. It's in the possession of Trooper Proctor, and the prosecutors do not know about it. After the trial, one of the employees from Norfolk County, Colleen Crawford, went to the sally port and looked at the DVR system. And when she looked at it, she saw that video still existed on that system. Although there was a 30-day overwrite on that system, the system had a number of backup hard drives. And because of the backup hard drives, the video existed longer than 30 days. She wrote an extensive report that was turned over to the defense, and this is after trial. The report notes her investigation about all the different videos, and it summarizes everything that she saw in that July 2024 visit. As I mentioned earlier, in August, Chief Rafferty provided video of the hallways that included some video of Brian Higgins, and she accompanied a letter or a note. I learned that that video was copied during the trial, and it is noted in the sergeant's letter. The chief of police and the sergeant were downloading video, not in response to a motion to compel or produce, but rather because they had concerns about accusations that were being made about the department, and they were saving video, in their opinion or from their perspective, to help defend against future false claims against them. They downloaded a number of videos that were then turned over in that August 2024 production. When I first learned of that August letter and note, I turned it over to the defense immediately. The issue came up regarding the DVR in November, and as we've litigated extensively, so I'll simply summarize it, I invited the defense to come to the Canton Police Department. Given the intermittent or spotty production of video, I thought it best they have an opportunity to look firsthand, although I didn't know if the video would exist, as I said. And then when they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing. I toured the entire station. I learned about the videos, and then as a consequence, I spoke to the chief, other officers, and the sergeant. Unexpectedly, the sergeant told me that he would click and drag copies of video when he would download them from the DVR. Inevitably, we had the litigation about whether the defense was going to download in person or not. And then as I tried to finalize my investigation into the tapes and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files, data, hard files, but I had not been on the case long enough to review everything. So I asked that the parties of the Commonwealth look through all files, all databases, so that I could help facilitate my review. At that point, I was provided by Trooper Tully the June 2023 CD with Trooper Buchanan's name on it. That is the exterior Sallyport video. And within 24 hours, I provided that to the defense. I then asked both the sergeant and Trooper Tully and Trooper Buchanan to write reports. Since there was no chain of custody, I wanted best to give as much information as I could and document the history of the video. That, Your Honor, is a summary of everything that I had learned, the investigation, and the production of the videos.
Do you know which investigator's file it was found in?
Trooper Proctor's.
Okay.
Your Honor, I have 3 separate arguments. I will proceed with the videotape argument since we've lodged into it.
Sure.
Okay. Now, the defense has made a number of conclusions that there was somehow videotape that was tampered with. There's absolutely no evidence whatsoever, none. It's not even speculation. There's no evidence that any videotape was ever tampered with. They say it, but there's none. I have seen none. They have produced absolutely no evidence that any video was altered or tampered. The defense lodges the idea of bad faith, that there was some type of advantage in that this video was withheld from them on purpose. And again, that is a baseless claim. If the government was going to hide video from the defense, they never would have got it. Maybe they would have got something after I came in and looked. They would have not got this production in April 2024. They would not have gotten the production if the government was looking to hide anything. And so the idea of intentionally withholding or bad faith is just characterization by the defense. The words Brady have meaning. Now, first, Brady needs to be exculpatory, and that's going to be something I think I can demonstrate does not fit this case. And secondly, in order to compel the court to conclude there was some type of remedy that should be issued, they want the court to conclude, like they do, that there was some type of tampering or some type of destruction of evidence. There was none. There was none. Now, Trooper Proctor had this video from June 2023 in his file. And I think the best evidence that this was not intentional is if you review Trooper Proctor's trial testimony.
So do you have a volume? Is it at the same place that Ms. Little gave me?
Well, I have the same volume. They gave you a fragment of his testimony, which is about 3 sentences. But if you actually read a number of pages of his testimony that deals with this video, and it begins on page 133, what you will see, and I won't spend a half hour reading it, but what you will see is that Trooper Proctor was aware of the grainy video, which was the video that was provided right after January 29, 2022. He was unaware of the inverted video until it was produced right before trial or right during trial by the Canton police. And you can also see that he in no way was hiding the June 2023 video, because you can see the confusion between all the parties at trial. Attorney Jackson is asking Trooper Proctor about video, and Trooper Proctor is explaining there is a Sallyport video, and also there's an exterior video outside the Sallyport. And it is clear that Attorney Jackson does not have that June 23 exterior Sallyport video because he's very confused in the questioning of Trooper Proctor. And Trooper Proctor continually tries to explain that there is both the Sally Port and there's the exterior video. So clearly, Trooper Proctor was aware of the exterior Sally Port video, but it will be clear from the reading of his cross-examination that there was no intentional withholding. He should have, since it was in his possession, whether it was relevant to the government's case or not, he should have provided it to the prosecutor, and then it would have been properly provided. But it was his oversight. There was nothing intentional or advantageous about it because he struggled to try to explain to Attorney Jackson. And so it's also notable that Attorney Lally never has an opportunity to ask more details about those. Well, he has the opportunity, but he doesn't ask more details about that misunderstanding because he's wholly unaware that it even exists. It's a confusing moment, but it clarifies that there's nothing intentional whatsoever about this course. And so it's important that although the defense now suggests there's something exculpatory about it or something about it that's important, it is important to note that the defense never filed a motion for the production of the Canton Police Department video. It is not incumbent or assumed that the Commonwealth is going to obtain every video from every part of a town during an incident. It's not assumed that they will do that. The Commonwealth seeks evidence that they think is exculpatory. They seek evidence that they think is relevant and material, and when they receive it, they are supposed to provide it. There are many cases where video from a police department is never provided to the defendant unless they ask. Or many cases where it may be a video of the booking, but not the hallways, not the bathrooms, not the back parking lot. Put in context that the defense theory was an evolving theory throughout this case to this day. The defense theory was that it was some third-party culprit, unidentified, who committed this act that led to the death of John O'Keefe. In fact, if you see earlier interviews, the defense position publicly was, you know exactly who did it, intimating that there was a specific person. Now that recently has changed. If we see the recent interview 2 weeks ago on Fox 25, the quick answer was, we have no idea who did it. We don't have to know. And so this fluid position is not noticed to put the Commonwealth on notice. They're supposed to chase down every potential idea or creation that the defense has. It's important to look at the motion that has been presented to your honor on behalf of the defense where they claim that they moved to preserve video evidence. And when you look at that motion, the best it says is that they moved to compel physical evidence. That does not put the Commonwealth on notice of video evidence at the Canton Police Department.
Was this the Stoughton District Court motion?
It is.
Okay.
And I know the Superior Court did not adopt it. However, I think the Commonwealth being on notice is the point. And even if it's in district court, I think it's the Commonwealth's responsibility.
I agree with that.
Okay. And so Attorney Yannetti, and I've mentioned this before, was very prolific in his pretrial discovery motions, very meticulous. And when you look at his meticulousness, if there was a need or a desire for video, he certainly would have asked for it. He didn't. In fact, when you look at the perspective of Attorney Yannetti, you don't have to look much further than his characterizations of how he sees the difference between the crime scene and the Canton Police Department. I've attached, for your honor and for the defense, exhibit number 4, trial testimony of Trooper Nicholas Garino. And when he cross-examines Nicholas Garino, he is pretty clear that there is a difference between the Canton Police Department and the crime scene. He cites on page 75, but you'd agree with me, the Canton Police Department wasn't the crime scene, correct? And Trooper Garino says, I never said crime scene in my report, I wrote scene. And Mr. Attorney Yannetti iterates, okay, well, Canton Police Department was not the scene of any crime, was it? So the defense is hard pressed now at this moment where they are trying to create prejudice that doesn't exist to try to convert a motion that they filed with very specific intentions for physical evidence to now suggest that that includes Canton Police Department because the Canton Police Department is somehow the crime scene. It doesn't convert. In argument, Attorney Jackson characterizes not only Trooper Proctor's testimony, and I encourage the court to look at that because when you read it in context, I think it clearly screams that Trooper Proctor is hiding nothing whatsoever. But if you look at Trooper Buchanan's testimony, on June 6, 2024, if you start at page 103, Attorney Jackson, and to paraphrase, I'm not quoting him verbatim, suggests that there's something about Trooper Buchanan that is lying about his position or about what he saw, or that Trooper Buchanan admittedly saw the inverted video. Not the case. Trooper Buchanan reported that he did not see the inverted video until after Canton produced it, because how would he see it before Canton produced it? And that was in his preparation in May. And he did not say that he sat down with ADA Lally and watched the inverted video. He was asked, were you shown any of the videos that you see in anticipation of your testimony? Now remember, there's not just Canton Police Department video at that point. There is video from Ring, Town Hall, a number of different places. And he said, not during the first meeting. I did review video during the second time. Question, okay. And that video that you did see the second time, was that the interior video of the Sallyport that we saw yesterday, correct? He says, Trooper Buchanan, I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meetings. That is what he put in his report about reviewing in May, not with ADA Lally. So I don't remember exactly what video Mr. Lally showed me. That wasn't the characterization that was provided in argument. This is very different. Question, but you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You've seen that one before. That's the inverted video. Answer, yes. I'm on page 104. And that was with Mr. Lally, correct? Trooper Buchanan, clearly. That is not correct because I do not recall when I saw that video or what video I saw with Mr. Lally. That sworn testimony is not only in stark contrast with the characterization that was offered by the defense, but it directly contradicts the conclusion they asked you to reach, that Trooper Buchanan watched this video with ADA Lally in preparation for trial. Therefore, it is a lie that the Canton Police Department provided the inverted video sometime earlier. That's sworn testimony. Now, again, trying to assert some type of relevance, the defense suggests there is something in the federal materials that would show relevance because Mr. Higgins said in the federal materials that he does not believe he made any phone calls. If you were to look at that testimony in the federal materials, you would see there was an enormous amount of conversation about the period in which he was sleeping. And there were dialed calls between him and Mr. Albert. And so you have to look at it in context rather than say it's an unequivocal denial and there's an aha moment. There is no aha moment. So
Do you have the grand jury cite? I think I might have got it from Ms. Little earlier, but the grand jury testimony of Brian Higgins, I have it. It's just easier if you have a cite to that.
I have a tab, but I don't, perhaps Attorney
I'm sure
McLaughlin
Ms.
does.
McLaughlin can get it
I'll
from.
provide it momentarily.
All right, thank you.
So what really arises from the subterfuge is that the defense did not ask for video. There was video provided when the prosecutors learned about it. There was video that was in the hands of Trooper Proctor that should have been provided to the prosecutor that wasn't. There was nothing done to alter or taint the video. There was nothing destructive about it. There was no tactical advantage. There was no benefit to the government. And clearly from Trooper Proctor's testimony, there was no effort whatsoever to hide it. It should have been managed better, no doubt. But there was nothing about it that was prejudicial. There was nothing about it that showed tampering or altering. And so ultimately, the import of the defense's argument is that this evidence, this information is exculpatory. It's exculpatory because what they claim is that it would show that Miss Reed's taillight was cracked, not missing a piece. Now, first thing we look at is Nick Barros's testimony. And if you have an opportunity to look at his testimony on page 12, line 1, the defendant told you part of the story. I saw there was some damage to the rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked. But they forgot the next part. And there, pause, a piece missing, but not completely damaged. That's exactly how we see Miss Reed's car later on after it is at Canton. The entire taillight is not missing. There is a piece missing. That piece, where the fractures of it are found at 34 Fairview, right near Mr. O'Keefe's body. The same parts of the taillight fragments that are found in the sleeve of his shirt. And so it's not simply cracked. Even the witness they tried to lean on, Mr. Barros, says more. And so if that taillight is not just cracked, that taillight is missing, then there is nothing exculpatory whatsoever about the Canton video. It's a red herring because there can be no plant of fractured taillight if it's already gone before it gets to Canton. There can't be. And so when looking at the evidence, it is unequivocally clear that piece of the taillight is missing well before that car ever gets to Canton. And so we can quibble and we can dispute and we can go back and forth all day, but the best way is to just show you the evidence. And so when we look at the evidence, let's start first with the fact, the claim that the Sallyport videos were tampered with. Canton went back before January 29, 2022, and they took samples of the video to see if it was in the same condition, inverted for the back wall and fuzzy for the front wall. And we have those, and we've turned those over to the defense, and I just want Your Honor to see a small clip of that to show this condition, these conditions existed before this case was even a moment. So with the court's permission, I'm going to ask to put up exhibit number 2. Exhibit number 2 shows the inverted camera from January 1st, 2022. Now this is 28 days before Ms. Reed's Lexus hits the Sallyport area. Now you can see, if you stop that please, thank you very much. On that wall, on that garage wall, there's a 4, it is backwards. This Sallyport video was not doctored by Trooper Proctor. It wasn't altered by Trooper Buchanan. It was in existence well before Miss Reed's car showed up to that Sallyport. Similarly, front wall camera, could you please put on exhibit 3? Exhibit 3 is from January 28, 2022, a day before Miss Reed's vehicle makes it to the Sallyport. And you can see the quality. It wasn't distorted on purpose. It wasn't manipulation by the state police. This is the way the camera worked in Canton. Thank you very much. And so the idea of tampering, we can claim it, we can assert it without fact, but we can prove it did not happen. Now, what we know is that missing taillight was not tampered with because it was gone hours before police even touched Miss Reed's vehicle. At 5:08 a.m., she left Meadows Road. That's John O'Keefe's home. And when she left at 5:08 a.m., that taillight part was already missing. If we look at Exhibit 6, please. This is from the ring video of John O'Keefe's home. This evidence directly contradicts the idea that the Sally Port video is relevant to show any break or planting of evidence. As Ms. Reed nudges into Mr. O'Keefe's car, she will pull forward and we'll stop the video in 2 spots so you can get a clear look of that rear tail light missing. Forward, please. Thank you. And then ahead one more. You can see the white light shine. Stop. You can see it clearly missing. You can't plant something that's already gone. And the reason why you see white, it is a red taillight cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why it shines white. The defense position is also contradicted by the ARCA witnesses. If we look at Dr. Wolf's testimony, day 31 of trial, it's noted as Exhibit 10 in our package, page 36. ADA Lally asks the good doctor, now doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th? He says, I'm not aware of that. And then if we move to page 124, line 1. Now, line 2. Now, as far as you're aware from your review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case? And Dr. Wolf says, at that speed, no. We provided notice of our own expert. And there's one thing, many things, but one critical thing the experts will all agree on. That nudging did not cause the damage to that taillight. The defense position is also contradicted by dash cam footage. Sadly, an officer went to the O'Keefe home to check on his niece and nephew on that tragic day. And when he did, he had a dash cam video further reinforcing that that taillight is missing well before that vehicle makes it to the Sallyport area. If we could play Exhibit 7, which is the dash cam footage showing Mr. O'Keefe's car in his driveway at 8:22 a.m. If you could close up from the court, please. If you compare the right side to the left side, although covered and impacted by snow, if you could more close up, please, you can see that taillight, just like the detective from Dighton said, just like the 508 ring video shows, is missing. Is missing. There's no plant. The defense's position is also contradicted by the alarm.com video that we received pursuant to Rule 17. There are 2 videos, 8 and 9. If we could play Exhibit 8, please. This is the defendant's car arriving in Dighton in the driveway. The defendant on the passenger side, and you can see them walk to the back of the car near the right taillight and stop. And if the question is, what are they stopping for? We can play video 9. And this is when the car is being put on the tow truck before it makes its canting. And just like 508 in the driveway of Meadows, John O'Keefe's home, you will see that right taillight shine white, showing the missing taillight cover on 2 occasions. If you have an opportunity to stop the video at the important points, please do so.
Can you lower it?
We cannot.
Can you zoom in on it?
Your Honor, I would encourage the parties to look at it on the computer. The clarity is much better and it's very clear, the white light in this video. I cannot see it clearly on the screen.
So will you give me a flash drive of all of these exhibits?
Oh, there we go.
Okay,
If you look at it on a small screen, see right
I
there?
do see it.
Yeah, and then you'll see it again. So the alarm.com video contradicts the defendant's position that there is anything exculpatory about these Sallyport videos. In fact, this whole idea of third party or plan doesn't come to town until 9 months after Ms. Reed is indicted. Perhaps the best evidence that contradicts the defense's position that there's any relevance to the Sallyport video, that there's any type of plant by anybody, is from the defendant herself. Ms. Reed spoke to Gretchen Voss on June 20th, 2023. And in that testimony, or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway. And so I say to the court, the production should have been sooner. It should have been cleaner. This should have been a log or an entry. The failure to provide was inadvertent. It was unfortunate. It shouldn't happen, but it's not Brady. It's not exculpatory. It's not intentional. It's not tampered with. It was inadvertent and inconsequential because the evidence is overwhelming that light is missing before the car makes it to the foot of the Sallyport, so there can be no plan. That is my argument regarding the Rule 14 issue. I would like to have time to speak about the claim of jury tampering. I understand the temperament of the court. I'm not tone deaf, but it is a claim that was lodged that has collateral consequence. And I think it's important for me to be able to address it. May I?
Yes.
The claim of jury tampering is probably one of the most serious claims that one can make because it's not simply an attack on a case. It questions the fabric of our entire judicial system. If a good juror comes to court and believes there is no integrity in the court or in the judicial system, it is impossible for a fair-minded juror to even consider evidence because they do not trust the system to begin with. And if a government actor or a trooper or a police officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen. Because of the collateral consequence of tampering with the jury, it would take away the community's belief in our system. On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial to impede the ability to have a fair trial. It is an extraordinary claim. And it's notable, the defense motion to dismiss is not just a motion to dismiss, it's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important because of the consequence of what happens when a claim like this is lodged. There is damage. And why I'd rather sit down, as I said before, a lie unchecked becomes the truth. And so how does one propagate a claim of jury tampering when there's no evidence? Well, first you need to plant the seed of corruption. And all you have to do is whisper it and hope the poison goes out there and is resonating in the potential community. And so what happens in this case? The defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. There can be no retort. The government can't respond. No facts, no evidence. Just saturate the public. Now, it's important to see or hear or read what is said, because this really is the acorn that is being planted that cannot be rebutted. And it's not insignificant that this same information before this interview is being disseminated by Mr. Kearney. This idea that there was tampering by Lieutenant Fanning. Not a coincidence. And so during this interview that the defendant and the attorney have, the question's asked, I don't know why it's asked, but it's asked. There have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. The question, is this a real concern that you have? Is this something that you were looking at, or have you just dismissed it as a rumor? Answer, I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it. And yet we have a motion filed 2 weeks later. Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question, one of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury? Not sure where these questions come from. Answer, right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well into trial. As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest. Question, is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah. Is it standard in Massachusetts? I hope not. Never seen that in my life. But if I had a nickel for every time I said I've never seen this type in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels.
So I didn't see that interview. I don't have the transcript. I'd like a copy of that transcript.
Your Honor, I understand. I may be mistaken. We produced all of the exhibits to the court, and you should have a transcript. If not, I will get it to you immediately.
Okay.
Okay. So after step one, finding a vehicle to plant the seed, and they did that very effectively, the next step is they have to identify a target. Who are they going to blame? Who's going to be the villain? In this case, a villain goes from anybody that gets in the way. It could be a soccer mom. It could be a police officer. It could be a good Samaritan. anybody that crosses the path is a target. And now they decided they were going to identify Lieutenant Fanning. Lieutenant Fanning is one of the most conscientious, dedicated, admired state police officers in Massachusetts. After having his name attempted to be sullied all over social media, attacking his integrity and his name, I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable, none of that will break him or his reputation. But it happened. When you look at the motion filed by the defense in this case, and they found their target in Lieutenant Fanning, you look at this motion, page 15. It's important when they made this public pleading, getting back to my request for your honor the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinate's disgusting and inappropriate behavior. As a result, he was investigated by the Office of Professional Integrity and Accountability for allegations of inappropriate correspondence between department members. True. But then they leave off the punchline. They put this in a public document. They try to smear him, degrade, demean, dehumanize. But what they leave out is that after this thorough investigation by the Office of Professional Accountability, where they took strong measures, very strong measures when they found something that they were not in agreement with, they concluded that these complaints were not sustained.
So we were all aware of that. I received verification of that through the Pleadings Council, was all aware of that. I just need the date. When was he cleared? When was that made public?
We'll have to provide that to you.
Was it prior to this? Was it prior to the motion being filed?
Yes, it was last year, last fall. I can provide the date right now.
Okay.
Trooper Lieutenant Fanning is not in a unique position.
If I may, Your Honor, sorry. It was July 17th, 2024.
He is similarly situated to the many first responders and witnesses in this case. And then, without any basis, the defense then distorts that Lieutenant Fanning was in charge of juror security. He had control of the jury, and he had access to the jury. Think about what those statements say to our community. We're going to pile in here in less than a month to try to give a fair trial to both sides. Think about what those words mean. After selecting their target and trying to dehumanize him and degrade him, they then try to create an illusion of this grandiose habit that is running amok. Trying to get the community to think Trooper Fanning controlled, had access, and tampered with the jury. Think about that concept. Not only is it an attack on Lieutenant Fanning, it is an attack on the integrity of the trial court. I've walked a lot of hallways in the trial courts over the past 30 years. And the heartbeat of trial courts is the court officers who take their duty so seriously. They help, they assist, they guide, and they have solemn pledges. They are charged with the responsibility of the jury. To suggest this is to suggest that the hardworking men and women in our trial court system who come here every day for everybody else's benefit, it is to suggest that they would cede their authority to the state police and abscond from their duty and responsibility to protect that jury with no basis whatsoever. That is the concept that they are promoting in this motion. The trial court personnel throughout the state are steadfast and dedicated. I've tried a lot of cases, and I think most of the lawyers in here have. It is without a doubt in Massachusetts that these dutiful men and women of the trial court protect and are sworn at the end of every case in jury instructions to protect the jury. And these trial court employees, especially here in Dedham, some of the finest, would never abscond that duty. And yet it is now in the public domain, this suggestion. The only way that you dispel innuendo, suggestiveness, unsupported claims, and the poison that can seep into the community, the only way you can stop that is with fact. So I'm going to list a few facts for the record. Fact, Lieutenant Fanning was not in charge of juror security. Fact, Lieutenant Fanning did not have control of the jury. Fact, Lieutenant Fanning did not access the jury. Fact, Lieutenant Fanning was part of a multi-agency cooperative effort to ensure the safety of the public and court participants, which required numerous local police officers and state police because of the bedlam that was created outside. Fact, Lieutenant Fanning never, ever, ever met with or interacted with any juror. Fact, at all times, Lieutenant Fanning worked from a remote location, jointly managing operations for the safety of the public. Never setting foot on this property when the jury was here. Never meeting a juror, never looking at a juror, never being seen by a juror. Fact, no evidence any trial court personnel ever ceded their obligations and duty and handed them off to Lieutenant Fanning. Fact, Lieutenant Fanning heard numerous rumors from various sources about a potential juror who expressed potential bias. Fact, Trooper Fanning never investigated, approached, or inquired. He heard the information and provided it to the trial court as is responsible, dutiful, and proper. And I'll repeat one more time, Lieutenant Fanning never, ever, ever interacted, controlled, or met with any juror. Your Honor, these claims in the motion to dismiss have a theme. Different issues, same theme, same pattern, same effort. Your Honor should dismiss it outright, and we should move to trial. Thank you.
If I may, Your Honor.
Yes.
Thank you. We're going to address in reverse order some of the statements made by Mr. Brennan. And I want to talk first about this issue of juror interference, which is what we called it. These words matter. We've claimed that there's interference. He indicates that that would be an abhorrent transgression if there were interference with a juror or a jury. We agree. It would be an abhorrent transgression. The information that we have in front of us is not the information that Mr. Brennan just recited, which is interesting. I'll get to the facts that he very dramatically stated in just a second, because this is a fact-based inquiry, one that we asked for standing right over there at sidebar and didn't get. But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that, recites these facts after facts after facts that he claimed absolved the Commonwealth of any transgression as it pertains to the jurors. And when I say Commonwealth, I'm talking about the Massachusetts State Police. Very clearly, in a clever, almost too cute by half argument, Mr. Brennan talks about the good court officers populating this courtroom and this courthouse, about whom we have made no allegation, no claim, nothing. We have nothing but the highest respect and regard for the men and women who wear that uniform and perform these duties. None, zero. And he knows that. But in an effort to create an enemy where there isn't one, he acts like we've insulted the court officers, which we haven't. He also said that Lieutenant Fanning stood up here and gave basically a CV, a resume for him, and said, the greatest guy on the face of the earth. I don't know Lieutenant Fanning. I don't know if he knows Lieutenant Fanning. Not really the point. It's in the personality contest. He said that we identified somebody with an unassailable reputation. We identified him. We didn't identify anybody. We were standing up at sidebar, fat, dumb, and happy, not knowing what was going to happen when somebody else identified him. Wasn't us. And by the way, everything that we filed concerning this was under seal. We didn't disclose anything in any court document. It wasn't a public document, it was under seal. Mr. Brennan then states that he was also a subject, this person with this unassailed career, was the subject of an IA investigation for his conduct on this case. It's not even about something tangential. It's about his conduct on this case, his supervisory role as it pertains to Michael Proctor and his, and I'll repeat it, disgusting conduct as it relates to my client and his text messages, etc. When he was asked about those text messages, his claim was, I was on vacation and I didn't read them. And ultimately, the Massachusetts State Police investigation cleared the Massachusetts State Police officer. We've seen that happen before. The question, or questions, if I could, that surround this inquiry, and the reason that we included it in our motion to dismiss is because it appears that Ms. Reed did not get a fair trial because of this juror's dismissal. How would the person who's unidentified, to this day, unidentified, how would this person know who the juror sitting in one of these seats was if she was at a private location? I won't mention the location. How would they know? How would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened? How would they know these things? How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically? And how would this unidentified person know of all of the authority figures to go to Lieutenant Fanning, of all people, who was then described to us after the fact as the, quote, commander of the extensive security operations that this case has required. And I went through that with the court this morning, but I just want to reiterate it one more time. Of course, it makes perfect sense that we would presume that if he's the commander, I don't think it gets much bigger than commander. If he's the commander of all security operations, he's the commander over operations that are attendant to the courts, the actual court's security, the personnel's security, the party's security to whatever degree that is necessitated, but maybe most importantly, the juror's security. That is a reasonable next step to conclude, a reasonable inference from the facts that we were given. But we do know this. He was this same Fanning that was just randomly picked to go report this to was also the person that was in Miss Reed's house seizing her phone just months before the trial. He's also the person that was interviewing witnesses or supervising the interviews of witnesses in this trial. He was also the person that was on the text messages between Proctor and his buddies at MSP talking about her and trying to find nudes. We know all of that existed. And yet we were denied an opportunity, Your Honor, an important opportunity to simply inquire before this juror was dismissed. That's all we asked. Let's get Lieutenant Fanning in here. Let's find out what the source of this is, and let's figure out, is it even remotely true? Remember, the juror never said it was true. But lo and behold, minutes before I stood up to give my summation, that juror is removed. That's the problem. This isn't about court officers and besmirching court officers' reputations. That's not what this is about. This is about what happened at sidebar in the matter of minutes that denied Ms. Reed her constitutional right. There's a couple of other points that I just want to make. Mr. Brennan started his comments by talking about the Sallyport video and how unimportant it is. How unimportant that video is. And I'm not going to go through all my points again. The court doesn't need to hear that. But I do want to make this point. He says it's not important. There was nothing to see here. We don't pull videos normally. Yeah, of course you don't pull Sallyport videos if you're investigating a bar fight. This was the purported murder weapon. This truck is the thing that the Commonwealth suggests was used to kill a cop. You think the video of it being pulled into the Sallyport might be of some evidentiary value? I don't know. Can't imagine why that would be important. Can't imagine why that might have some evidentiary materiality. But I do know this. I do know this much. One guy who thought it was important, the lead investigator, he pulled it all of it. He was super convinced it was important. And he's the guy that once pulled it, hid it from us for nearly 3 years. Mr. Brennan spent some time talking about the difference between cracked and missing. Interesting point. Now, I'm not going to go through a bunch of videos and audios. The court has seen all the pictures and photographs that it needs to see, and the court has a very, very good memory. We've never, ever disputed that the light was cracked at 5:07 or so a.m. That's how it got cracked, is the point. It got cracked on that traverse. And a piece was missing. A piece was missing. Not according to me, according to another agency's sergeant, Barros, who said a piece was missing, but it wasn't completely damaged. Recall that when that light was completely reconstructed with the 46, 47 pieces that were purportedly found, well, they were found at or near 34 Fairview, and then they were reconstructed. Does the court recall what that reconstruction looked like? That taillight was put together almost in its entirety. Almost, except a piece was still missing. There was a piece unaccounted for. There's a big difference between a crack and the condition of that taillight, which we've now seen, where literally the entire lens material is basically gone. There's a few shards left on some edges, but the entire lens is basically gone. So yeah, it's relevant and it's exculpatory. The condition of that light when it pulled into the Sallyport driveway. And with regard to the inverted video, again, Mr. Brennan says there's nothing to see here. We've got inverted videos dating back days earlier. Then why, if that's such common knowledge, then why did Mr. Lally and Sergeant Buchnick in front of a jury present that video as a true and correct presentation of what that car looked like and where that car was? Mr. Lally actually asked the question. I don't have a page and site number, but I remember it because I was sitting here. He asked the question, did you see Mr. Proctor, something, I'm paraphrasing, something along the lines of, did either you or Trooper Proctor approach that right passenger taillight? And the answer was no. Because on the video that was being played, it looked like the right passenger taillight was the one closest to the jury. And of course, Trooper Proctor walked right around that and went over to the other taillight. Except when you reverse it, you realize that's the right taillight.
Is there a copy of the reverse, the one that you played? Is that in the exhibits for today's motion?
No. The one that's been corrected?
Yes. I'd like a copy of
I
that.
don't think I have. Sure. We can get that for the court immediately. Also, he played a video of the grainy video showing, hey, look, some of these cameras are just grainy in other particulars as well at other times and places. Maybe, or maybe not. What's interesting is the grainy video that we saw, if my memory serves me, and it's my memory and it's being taxed at this point, but my memory is the chyron on that video, in other words, the running numbers, was at the bottom. That video he just played is at the top. That's the exact same video. If it's apples and apples, oranges and oranges, why is that different? That's interesting. And with regard to Ms. Reed's actual statements in that interview that was played, or I'm sorry, it wasn't played, it was recited. She said, some of the red plastic is missing. Some of the red plastic is missing. In other words, a piece is missing. It's completely consistent with the condition of that taillight before it was at the Sally Port. With regard to the facts that were recited by Mr. Brennan at the very end, every one of those is unsubstantiated. How does he know all that information? Who has he been talking to? And why don't we know about it? If in furtherance of this motion, there was an interview done of Lieutenant Fanning that laid out all of this information about not having contact with jurors and not doing this and not doing that, but yes, doing this and that and the other thing, why's the first time I'm hearing about this when he stands up and tells us? That has been the pattern of this Commonwealth's presentation to this court and in front of the jury consistently. That is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion? Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about? This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should, the maladies of the Brady concerning the Brady violations and the discovery violations are so manifold in this case. They cannot, it's
This is on, not on my end. Just going to check and see on another channel. But I suspect this is the court feed. You guys can let me know. WCBB has it. All right. All right. Hold on one second.
expect that we would finish all the motions in limine in 2 days and wrap up whatever we have here. All right. All right. Yes.
Fox 25 produced the materials at the beginning of March 1st. I went down to see if I could get a copy. It's on a hard drive. I can't simply look at it in the clerk's office. I would like permission from parties to be able to make a copy of the hard drive, or if I can get the hard drive and make a copy and return it.
Does the defense want a copy as well?
Yes, Your Honor.
All right. So you can make copies.
I'll make 2 copies and then I'll return the original to the court.
Okay. All right.
Just before you leave the bench, Judge, I do not want the court to decide that motion for sanctions until I just supplement the record. I could do it in 3 minutes, and if
Go
you
ahead.
don't, you can cut me off.
Go ahead.
Thank you.
Go ahead.
Just briefly, Judge. Yesterday, Mr. Brennan represented to this court that I had made an extrajudicial statement regarding Mr. Morrissey and the federal investigation. You'll recall that I stood up in rebuttal and said that it was in court advocating for my client. He then said court TV is not a courtroom.
So before you go further,
Yes.
I don't know if Mr. Brennan was going to give me a court TV site on that. Is
Right.
there one, Mr. Brennan?
I'll have to provide a video. I think that Mr. Yannetti is referring to that comment that was in the court file. And so I intend on remedying that record. There was also a conversation after with court TV.
All right. So provide it to Mr. Yannetti. Mr. Yannetti, I'll give you an opportunity to respond once you get that. But go ahead. You can tell me what you want to tell me now.
Right now, it's out in the court of public opinion that I made this extrajudicial statement. I said specifically I did not. He contradicted me, and that's where we left it. And he said that he would produce the receipts. Now he's admitting he does not have the receipts. There was no court TV interview where I said anything of the sort. That was a Zoom hearing, where I was arguing before Your Honor. I would just note, Your Honor, I don't think it makes sense that Mr. Brennan would have done this on purpose because it was so easily disprovable. It's troubling that he would make this damaging accusation without properly vetting it to see if it is true before he attacks opposing counsel. So that was disappointing to me. And I would just point out, and again, I only need 30 seconds, that
You can take your time, Mr. Yannetti. You're not going to be
well, we're all
45 minutes.
right. I certainly will not be. This new false allegation comes after my colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court. And I want to make it clear, I don't need an apology from Mr. Brennan. I don't expect one. But I think perhaps he should apologize to the court. He said today, a lie unchecked becomes the truth. And I just would hope, Your Honor, that you hold Mr. Brennan to the same standard that you hold the defense team. And that's it.
I certainly do. So, Mr. Brennan, if you do not have a site, then I need you to let us all know that as well.
I will. It's convenient to retort that there were 10 lies by the court that Mr. Alessi lined up. In fact, I looked at the transcripts. Some of his suggestions that I didn't read the paperwork properly, which is wrong. I didn't try to shame him today. It was part of advocacy, and I accept that. There was a conversation, and if you remember, when I related Ms. Yanetti's remarks, it wasn't in relation to 3.6. It was in relation to the fact that they were using the federal investigation to create innuendo that could not be responded to. But I will provide.
For your request for the gag order? In support of your argument for the gag order?
In response to how they had used federal materials that were under seal that couldn't be rebutted to make suggestions. It directly related to that point, not 3.6. But I will provide the videos. Mr. Yannetti is right that the exact statement that I used was from a court hearing, but then there were subsequent statements made. And so my regrets to Attorney Yannetti, but it wasn't in the fashion of a 3.6 violation. That wasn't the intention. It was to show how they've used these federal materials before the case was closed to their advantage.
All right. So if you have the site, I'll give you until tomorrow afternoon to find the Court TV site.
Very well.
If you have it, supply it to all, Ms. Tianetti. So I'm ordering the Commonwealth if they have that Court TV site to provide it to all of us. And if you don't, provide that as well. Provide
Very
that
much appreciate
information.
it.
as
Thank
well.
you.
Thank you. All right, that's it for today.
All rise to the court, please.
You are muted.
Wow, that was fireworks, every bit of that. And I know that, let me just take this off. I know that people on either side are going to have certain feelings about the other side's lawyers. And I believe that Hank Brennan did a great job of showing that most of what the defense is pointing to here is bullshit. But at the same time, just stand back for a moment and appreciate it. These were two powerhouse lawyers, as best as you're going to see, going head to head. And you're not going to see anything like that ever again. That was pretty incredible. I mean, because they don't go up head to head in the trial. They're going through witnesses. So that was pretty stunning. I also, as much as I think Brennan steamrolled today, was incredibly effective, brilliant. But I did, what Unetti just said there. I thought the same thing yesterday. I remember hearing it, thinking, I don't think that was court TV. I think that was in court. So that's now two pretty big blunders. They're just blunders. They're not intentional in the last few weeks on this. And so he needs to get someone to help him a little bit with the research here to make sure if you're going to quote somebody else that it's accurate. They're obviously blunders. They're not intentional, but they're big and they shouldn't happen. And now there's been two of them. So, but that said, this was, to me, very decisive day for the prosecution. I know people in the pink crowd won't agree with that. But if you know the actual evidence, what Brennan did today just laid waste to the entire, it has so thoroughly laid waste between last week and today, between yesterday and today, to the third party culprit theory, that there's nothing left to stand on. The only thing left to stand on is the idea that John, think about this. We've got to believe that Karen Reed is innocent. You have to believe that somehow John went into the house despite the fact that his phone never did. That's just factual. His phone never went in the house. There's no point really spending a lot of time arguing it. The GPS, which is truly accurate data, shows that it never went inside the house and the phone stopped moving at 12:32 and 16 seconds. So if you're a serious person, not whether you want to be a serious person or not is up to you. But if you're a serious person, you have to accept that GPS data is a million times more accurate than a phone app, than a health app, which is just trying to interpret your emotions. GPS is designed to fly a missile up a camel's ass from 1,000 miles away. That's what it's designed for. That's what it does. That GPS chip that is in your phone, that's what it's designed to do. And that's all it does. There's a special chip that is manufactured to go in your phone. That's not true of a health app. The health app is trying to interpret what you're doing based on motions. That's always going to be imperfect. And it does the best it can. And it's pretty sophisticated technology for what it is. But GPS just has to determine your location. And it's very, very good at doing that. And you always know what the degree of accuracy is, what the margin of error is. And it shows that John never went inside the house. You can't just ignore that. All right. Now, same thing here as we've established with the taillight evidence. And Jackson very weirdly, I guess gamely, the best he could with a bad hand, he tried to say, well, when they reassembled that taillight, there was still a missing piece missing, right? That's probably the piece that Karen dropped in the driveway. But that little tiny missing piece certainly is not what Karen was describing in her own words in the interview with Voss. Not even close to that, right? It certainly is not what we see in those videos. So it's absurd. Unless you want to try to stretch this out on this absurdity, just like with the GPS, you have no choice but to accept that taillight was missing those pieces before she pulled out of the driveway at 5:08 in the morning. Period. There's no reason to really, there's no sane reason to consider anything else. The entire, if we're going to be rational and reasonable about it, the entire Karen Reed argument is now reduced to something had to happen in that garage. That's it. There's no other way. Someone had to break into that garage and tamper with those pieces and then sprinkle them on John's clothing and deposit pieces at the crime scene. There's no other way. You can't even explore anything else. That's it. That's the end. The defense team has been pushed out onto the edge of the plank, and now they're just standing on the edge, looking down at the water, and there's nothing else. They're right on the very edge. Hank Brennan has pushed them all the way to the edge, and they got nothing else. They're looking around. They can see the sharks in the water below, and the only really thing that they're hoping for here is they see this little tiny life raft coming over, and what's in that life raft is a juror that, like this dismissed juror, is part of a cult and got on the jury by lying, by misrepresenting the degree that she had made up her mind before she got on the jury, and by lying every day in court that she was following this. That's their only hope. That they're standing on that plank at the edge, looking around, and they see that lifeboat, and they're hoping they'll fall into that. And Nick really kind of unintentionally, I don't think they prepped him well enough before yesterday, but he let loose that's the strategy last night on court TV. Because he said, even though the federal investigation is over, or even if it is over, he's maybe one of the only people in that group that's willing to accept that. Even Karen wouldn't accept it. But in that setting last night, I guess he had to, because he knew that it would have sounded foolish not to. So he said, but even if the Fed investigation is over and they didn't find anything, it still remains that we're in a better situation now because more of the public is aware of our arguments than in the first trial. So what he's talking about there is jury pool contamination. That's their best hope. And then he went right to the next statement. He said, and I don't think the Commonwealth wants to go through the expense of this a third time. This is all that's left. And David Yannetti knew this in January because that Boston Globe story came out that was really bizarre. Somebody had to have a connection to get that pushed in the Boston Globe. But that's their only hope, is to get a juror on there that nullifies the process, that lies every time she raises her hand under oath, which this dismissed juror obviously did, and wants to prove themselves to Karen or to Turtle. And that's it. You're not going to get 12 jurors to buy into any of this nonsense put through by the defense. You're not going to get 10. The jury contamination is enough that you might get 1 or 2. And that's their best hope. And they know it. It's not like they don't know it. That's why they pushed that series in the Globe. That's why Nick said that on TV last night. Acquittal is not really in the cards here, barring some new evidence. And you can see it, right? They're grasping at straws. They're making desperate plays here. They're putting things in motions that they know have no chance, but they think it gives them a chance to further contaminate the jury pool. But it's backfiring because Brennan is taking advantage of that too. So you want to play that game? All right. You want to do that? I'm going to show you those videos in court again. And that's the first time we got to see them all together in the court setting because they came out through different witnesses during the trial. But now Hank Brennan got to show the 508 video, the 822 video, the tow truck video, got to also give us for the first time the transcript of Karen's words to Voss. They also, if he wanted to, he could have went with Kerry Roberts' testimony too. They can add that to it too. So that taillight was missing pieces, was missing a large piece from the corner that disintegrated at the crime scene. There's just no room to go anywhere else unless you want to try the strange argument that somebody snuck into John O'Keefe's garage and tampered with that vehicle, and they were undetected by John's security systems. I don't know what he has. We know he has Ring. So Ring would have picked up somebody and woken up people inside. had somebody been going through that driveway. And I don't know, maybe he seems like someone that might have had a more extensive security system, but I don't know. We're told he had a digital key lock. Does that suggest that they had an alarm system there? Maybe. I don't know, but we don't know if they did. We don't know if it was set that night. Um, but that's a really, really thin ledge that you're now clinging to. The idea that that somebody broke into the garage, but I'm afraid that's all that's left for them. Hank did a very good job eviscerating the Higgins stuff. There's no evidence that Higgins was deceptive in trial. We don't know what we can't know what the federal grand jury questioning was, but it sounds pretty clear that what he was saying was, I didn't make any calls in the middle of the night when he was sleeping or when he was home, napping on the couch. That he wasn't talking about, did he call somebody from the car on the way home? Did he call somebody from the Canton police station? He wasn't talking about that. And we don't even know that he actually made a call. He might have been just checking voicemail. The important thing to know, though, is the feds got his phone communications. They know exactly who he called. And if it was exculpatory, they would have brought it up in the federal grand jury and they would have turned it over. And so I'm going to suspect the defense probably knows who he called to, but if they don't, we can deduce logically, because they do have the transcript, that if it wasn't important to the feds, and the feds were doing everything they could to try to help Karen here, for whatever reason, the fact that they didn't bring it up and they knew who the call was, then it wasn't important for him. So probably he was checking voicemail. That would be the most likely explanation, but we don't know, and it's none of our business because it's not relevant. It's not material to anything. So whoever he was calling, it's his business. That's the bottom line. So, I hold on a second, just checking. All right, let me just check email for something. The person that just sent this to me, I'm saying thank you. I'm not mentioning your name just on the chance that you don't want to, and I'm not sure if it's going to be interesting anyways. Let's see. All right, so it is important if it's true, but I don't know if I should repeat it since we don't have any verification of this. All right, so I'll just address it because I'll say we can't verify this. So I'm not. So what I'm going to say now is something that somebody has put on Twitter, and then somebody sent it to me. And the name on Twitter does seem like is not someone I know personally, but I've seen the name in there. I have no reason to think this is someone that puts out misinformation. But then again, we all have to be careful about information that's out there. So what this says is that some of the deleted Ring footage shows Karen picking up small pieces of her own broken taillight out of Officer John O'Keefe's driveway. So I don't know how that could have been recovered, though, because that video is missing. This must have been the couple of small pieces missing from the reconstruction. So, I mean, I don't know, because as far as we know, what we saw during the trial, that the Ring video of Karen, Kerry, and Jen, when they leave, they go out, and according to testimony, Karen and Jen and Kerry examine the taillight, but they don't drive that car out. That car is parked there. Jen had parked it there, but they get into Kerry's car and they go out looking for John, and they find him a few minutes later. So, actually, I can take this off. Just gonna plug this in. Sorry, just bear with me for 1 minute. I gotta plug this in because I'm on Court TV later. So the with video that's missing in probably 3. So Karen arrived back at John's house at, according to quote Trooper Garino, around 12:36, and then She leaves a voicemail at 12:37 that says, "John, I fucking hate you." Then the next voicemail is at 12:41 that she leaves no message, but it picks up her what sounds like her pulling into the garage. You hear the alarm noises from the car as it detects a nearby wall, and you hear what sounds like the garage door closing, and then you hear her boots. She doesn't say anything, but so that seems to be the moment that she took the car into the garage. So it would seem that she got there at around 12:36, parked it in the driveway, probably because she didn't have a garage opener. Remember, she doesn't live there. And she went into the house. Maybe she used the bathroom or whatever. Maybe she checked on Kaylee. We don't know. Probably went to the bathroom. She's been drinking a lot. So then she goes out and moves the vehicle into the garage. But the video of her getting home is missing. The video of her pulling it into the garage is missing. Presumably, that's 2 videos. And while we do see video of her leaving at 5:08, and then we also see video of her, Kerry, and Jen arriving at about 5:30, 5:45. I think 5:45. We don't see the video of them leaving. So there's no proof that these videos were deleted, right? We don't know what happened. Were they somehow missing? Did the Ring camera not, for some reason, detect motion? Now, that seems unlikely because they were detecting things perfectly fine at 5:08 and when Karen and Jen got home, and then later on. So I don't know. Was there possibly snow on the Ring? Did blowing snow get onto the Ring so that interfered? But it's pretty convenient that the missing videos all likely involve moments when Karen was examining her taillight. Now, we don't know that she examined her taillight at 12:37. We know that at that moment she had just got home and she called John and said, "I fucking hate you." But we don't know the Ring's missing, so we don't know. There's no evidence that she examined her taillight at that time. But there does seem to be indications that she was aware of it. And that doesn't mean that's the moment she came aware, but she was aware of it when she talked to Jen on the phone. I believe that was the testimony around 5 a.m. So, and then the testimony of both Kerry and Jen is that Karen showed them her taillight. They examined it together at about 5:45 in the driveway. And now we know that that's what she told Gretchen Voss, that they examined the taillight at that moment. And that's when she plucked the pieces out. Now, the idea that there was just this tiny piece missing, as Alan Jackson desperately is trying to go with now, and it's desperate. That's ridiculous. That tiny piece would not have made what's clearly a significant missing piece on the video, and that would not have been enough to get the description that Karen had when she talks about she was worried about the operation of the vehicle and she could see the light bulbs and this, that. That's not going to happen from a thumb-sized piece of taillight missing. So that's absurd. So I wish we knew more about when these Ring videos were deleted. Unfortunately, we don't. Now, I have not seen anything new on that. I haven't seen that there's going to be new expert testimony from, for instance, somebody from Ring. I haven't seen that. I would have liked to have seen that there's going to be an expert from Lexus that's going to come in and talk about key cycles. Haven't seen that. So, and it's getting pretty late in the game, so I don't think those are going to be added to this. So I guess the Ring video, unless I'm missing something, will probably remain a mystery as to exactly what happened. Anybody could have deleted that video. You don't need the app on your phone. I could have deleted that Ring video if I had John's email, which presumably that's the account name, and his password. So if you got the sign in and the password, any one of us could have deleted that video. The question is who had an incentive to delete that video? And the only plausible answer that we have on that is Karen, because it seems that probably those were all videos that showed her examining her taillight. So I mean, I mean, I guess you want to try to posit some kind of thing where there was conspirators sneaking around the yard at 12:36, and that's missing. I don't. That seems crazy, right? So, or you want to posit the idea that the conspirators later on were deleting an image, like let's say around 4 o'clock, some ghost, maybe some member of the CERT team that they've already got in, broke into the garage, going through the driveway, and the Ring video picked it up, and so they had to delete that. And for the heck of it, they deleted a couple other ones that were irrelevant. I don't know. It's thin. That's how thin it is. That's how thin it is. The most logical explanation is obviously the defendant didn't want to be seen examining her taillight. So at some point later, she deleted them. And I'd be interested to see when Procter and Buchanan learned that those videos were missing. Did they learn the next day? Did they learn weeks later? We don't know. That's something that should have maybe come out in trial, because the later that is, the more there's the opportunity for Karen to have deleted it, if that's what happened. Funny Bunny says, I think she tried to delete all the video and failed. I don't know. I mean, there's no evidence of that, so maybe, but all right, so there's definitely, I forgot to say thank you to the people that have been so kind during the show. So Fraud, these are from a long time ago, so I don't know if these questions will be relevant anymore, but we'll see. So Fraud, thank you very much for your competition. After court, Karen Reed said, this is after court yesterday, that the investigation is ongoing. If she took Brennan at his word, it would be a very dangerous endeavor. So yes, I played that, I think, yesterday. So Karen did not believe Hank Brennan when he said the investigation was over. Now, the idea that Hank Brennan went out and lied about this, but not just Hank, but that I lied about it, Ted Daniel, Christina Rex, and I don't know whoever else, because they weren't getting this I didn't get this from Hank Brennan or anybody connected to Hank Brennan. The U.S. Attorney's Office called the Canton Police, they called the Norfolk DA, and they called the Mass State Police. All right, so that's so for Karen to believe this, that's kind of crazy. But she has no choice, right? So wicked smart. Kevin, please eject Aiden from this chat. So this was a long time ago. I didn't see that message. I did, I try to let Aiden or anybody else be here, and I don't know if it was the real Aiden. People were saying that it was a fake Aiden, but and then other people were saying they were enjoying that. But you know what? If the fake Aiden is listening to this, don't do that anymore, because I can only see a certain percentage of chat. So if I look down and I see somebody pretending to be Aiden talking about dicks and blowjobs, which he was, I'm going to boot him. And I might blame Aiden. And we shouldn't be blaming, I don't care how much we might not like Aiden Kearney, we shouldn't be blaming him for things that he didn't do. So don't do that. Let's just call that a rule from now on. It shouldn't have to be, it's self-explanatory. Do not pretend to be somebody else. I don't like it when they do it to me. There's a whole fake Yellow Cottage Tales on Twitter that puts out false stuff all the time, and it's fooled a lot of people. It's fooled John DePetro. I think it fooled Kevin Mahoney once back in the day. But it's fake, and I've tried to go through the process of getting rid of it, and it doesn't work. So don't do that anymore. Okay, don't fake being someone else. That's just not cool. Maui gifted 10 Yellow Cottage Tale memberships. Thank you, Maui. And so those lucky viewers that got that will be thinking they got something special, and they'll be like, shit, I didn't get anything with this. But thank you, Maui. And then she gifted 5 more. Wow, Maui, thank you very much. You're bringing up the memberships. And most of those people will probably not want to stay on, but hopefully some of them will. Another one, she gifted some more. Thank you very much, Maui. So you got our numbers up. That membership total that Maui just gave probably gave us like a 10% boost in total memberships. So thank you, Maui. And Alma, thank you for your donation. Very much appreciated. Alma, if you're still here, these were from a long time ago, so I apologize if I didn't get to say thank you then. Darlene Horn in Canada, donated $5. Thank you very much, Darlene. We love our Canadian fans like Caroline Sweet and my friend Colin. Funny Bunny said, thanks, Kev, Joe, and Fleming. And it's when I say Joe, my other moderator, that's a woman. So that's J-O. It's not Joe like in Joe Krowski's not my moderator. Ashley said, lock him up. And Funny Bunny, oh, we already got to that. So, all right. Thank you, Funny. All right. So we'll just look real quick and see if anybody has any questions, and then we can all call it a day. But this, again, go back. It might be worth watching some of this again today. This was two legal titans going head to head, and that was something to watch. So Andy says you can restore a deleted ring video with data recovery software like Wondershare, recover it, but only if you previously saved it on your device. So, yeah. And I was really glad, and thank you for talking about transparency. I was really glad that Hank said, yeah, if, Caroline is actually here. Thank you, Caroline. He said, look, if we were trying to hide this video from you guys, you wouldn't have got it now. So, I mean, Brennan's normally a defense lawyer, right? And he's making sure these guys get everything soon after he gets it. Haven't spoken to Kevin in a while. And so thank you for Joe and for Tom for being here as always. Thank you, guys. Tom, I did not get to the post office, but tomorrow I will have time. Yeah, I thought that was I thought both lawyers were very, very effective today. I mean, Alan Jackson being shady, but he's got a bad hand. He's getting paid. Hank is paid to get to the truth. Brennan is paid to get his client off. And no, I'm sorry, Jackson. Jackson is paid to get his client off. So, he's got a bad hand at this point, and he's doing his best to play it. And I just strictly from a lawyering point of view, I thought he was brilliant today. But I also think Hank was brilliant too, and he's just gonna keep steamrolling. He's just gonna keep coming through. Like I said this morning, he's like the Roman legions. He's not trying to surround you. He's not trying to cavalry charge you. He's just lining up legions of troops, and they're marching one step at a time, and you can't stop it. You can't stop it, and you can't. So he just doesn't. He explores every angle of it, and just he leaves no stone unturned. Anybody else have any other questions? Yes, on Court TV again tonight. One of the things last night when I was on, I don't know if you guys saw, but Peter, who is always there to argue for the defense, said that because the federal investigation was over, that only means that they didn't find a smoking gun. In other words, wow, there really could still be a conspiracy. They just didn't quite find enough to indict. But when it came to me on my segment, I had to wait through the commercial break, but I was like, no, that's not really true, Peter, because the TUI process, they were required to give any remotely exculpatory evidence over. So anything that even suggested there might have been a cover up or a conspiracy, they had to give that over, and we would have seen it in court. So no, the feds didn't find anything exculpatory of for the defendant. So Joe, actually, I'm glad you bring that up. So because we had that little kerfuffle where all of a sudden the monitor went out, which seemed to be a court TV problem, and I got it over to WCVB, so that was good. Thank you guys. But we missed something there. So is there a hearing Friday, or is that just a deadline day now? Is there an actual hearing on Friday? And as far as Turtle Boy, the only thing I saw, I think somebody in chat said here that I don't know if it was continued till noon tomorrow. There's something going on noon with it, so I'm not sure. Maureen says there was next hearing is Friday 9. So there is a hearing. No, so Ken says there's no hearing though. So we have a dispute. So what do you guys think? Is there a hearing Friday? And thank you, Alma. Is there a hearing Friday on Karen Reed? And Mama, thanks for the help. Yes, give me a thumbs up. You know, we don't usually ask for anybody to subscribe or give a thumbs up. And keep in mind, we're still linked right now to Jen Coffenaffer's channel, Breaking the Case with Jen Coffenaffer. I think Matt's channel might still be up here. Let's see. So, yep. Masshole Mafia, Kate's channel, Boundless Millennial Matt's. So they're all still broadcasting this right now. We all stream this together. So please go in and support them and give them a subscription if you don't mind. Doesn't cost you anything. So Dixie Doodles, this is probably Jen's moderator. Not really sure. I see that you're a moderator though, but thank you for being here and trying to help us keep this clean. So Rainey is going to address an email. He is more leans on the free Karen Reed side, or at least he did the last time I talked to him. He's a good dude down in Florida. Look forward to your email, man, and I will answer it. But I got to think, Rainey, if you are approaching this objectively, that what you've learned last week and this week, especially in the last 2 days, has impacted your opinion, right? And just, you know, you've told me that Turtle Boy is interested in the truth. But come on, man. We just learned that the Fed investigation is over, and he still won't accept that. So that's not someone that's interested in the truth. It really isn't. No, you can. No, I'd be happy to have the email from you, man. Happy to send me an email, please. Take your time, put it together, everything you want to say, and I will get to it. So no, please, by all means, send me your email. And B Blanca is also a moderator. These people, guys, they could be moderators for Jen's channel or Matt's or for Kate's. So your conclusions are not only possibilities, Kevin, others are allowed. Yeah, but they're more than possibilities now, Rainey. The logic has really eliminated the idea that the taillight was tampered with in the side port. It just was. There's no room left for that anymore. You know. There's no room left for the idea that the taillight was planted after 5:08. There just isn't room for that anymore. So, so I don't know. We'll keep working to find out if there is a hearing Friday. But so we will cover it though. I don't know what the situation will be. I have to leave for a doctor's appointment in Boston. I have to leave at about 10 or 10:30. Say about 10:30. And so Kate's channel is Mass Hole Mafia. But what I'm going to do is I've already given it to her, but in case she's doesn't have enough, Kate will be able to log in. I'm going to log into my channel. Well, assuming the hearing starts at 9, and I will be here for the start of the hearing. And sorry, I was just reading the chats. So I will be here for the start of the hearing, and then if I have to leave to go to Boston, I will just leave it up. And in fact, when I get to Boston, I'll be watching my channel from that. But I will also give Kate my password and stuff. She already has it, but I'll give it to her again, and she can make sure, because we see sometimes there are technical issues. Like I leave it on a channel, and all of a sudden the feed dies out. So she'll have that, and she'll be able to jump on it and set it up get it over to another feed. According to the docket, Friday's hearing has been rescheduled next date, 3/18 at 9 a.m. Okay, thank you, Nancy. So looks like we don't have to do anything Friday, which is always good. So if Nancy's information, Nancy from the 508 is correct, then there is no hearing for Friday. And that was my sense of it yesterday, that they actually had got rid of that they were just going to use Friday as a deadline. They managed to get everything done that they wanted to yesterday and today. Rainy, email is good. If it's long, email. I can't. You can text me. You have my number, short text, but send me. I check all my emails always, and I can't. It's hard typing on my phone. So, but with the email, I can go to my laptop and just and type a lengthy reply. Caroline, driving to Toronto to visit Dad for 95th birthday. Wow, that's congrats to him, man. That's a good achievement, especially for a man. Men don't usually live that long, right, like that, to that ripe old age. But it sounds, Karen, like there is not going to be a hearing Friday. So unless we learn something different, there won't be. And Blanco. Oh, so this is the same Blanco that I became friends with out in Dedham. I did email you my number. I'll send it again. Thanks, Tom Plummis. Oh, okay. Did you want me to call you? I'm not sure what you needed, Blanco, but I'm here for you, brother. Okay, so it sounds like no hearing this Friday. Getting other sources on that. So sounds like no hearing on Friday. So that'll be nice, and we get to enjoy the weekend. I'm sure as with this case, there's always new breaking news. So we'll see what happens with. From what I could see from somebody said in chat here that Turtle Boy. This may not be the correct word, but there's another hearing at noon tomorrow. So I don't know if that was a continuation from today. And I guess when there was a streaming link, there was a Zoom link that some people were able to stream it, but there was no audio. So people really don't know what's going on. When we were listening to the hearing too, we heard a lot of cheering outside. So that's presumably when Turtle Boy's hearing ended and he went outside as the conquering hero and the zombies cheered. So I would say that there were plenty of pinkies in front of the court today, Funny Bunny, based on the cheers that Turtle Boy. I'm assuming that was, maybe it was something else. Maybe there was a parade going by. I don't know. Nancy went to the court website. So the next hearing is on 3/18 and 3/19, which those are big days too in the Karen Reed case, because on the 17th, St. Patrick's Day, is the first night of the documentary series that primarily stars Karen. I'm also in it. And some other friends of John's, like John Jackson and Brendan Kane. Possibly some people from the scene too, in Dedham, like Steph and Kerry Lama. And that's going to play 3 nights in a row on HBO Max and Discovery ID. I think each night is like a 2-hour episode. So that'll be on. It's on Discovery ID, yeah. But it's also on HBO Max. As far as court TV, now we have it on our TV channel here, but I know a lot of areas don't. I believe, although I'm not sure, that you can find it by going to their website, not to YouTube, but to their actual website, courttv.com or whatever it is. And I think they show them the shows live on there. Not sure. Carolina, if you're talking about the documentary, you'll be able to see it on HBO Max. It'll be on HBO Max. And Ken Weeks says nothing this week or next week, the judge said. So that confirms it. Okay. So Justice Lane said, she's new here. What is your name? I'm not sure if you're talking to me or someone else in chat. My name is Kevin, and not with me at the moment, but their channels are on is Jen Coffenaffer from Breaking the Case with Jen, and Boundless Millennial is Matt Doherty, and Kate Peter from Masshole Mafia. So whichever channel you're logging into. Oh yeah. So my channel is actually Yellow Cottage Tales. So if you're watching from one of the other channels, I can't tell. But so if you're looking for my channel, it's Yellow Cottage Tales on YouTube. Macy, thank you very much. And so I'm ready to see what the battle plan is and take it on. Hopefully there is a battle plan. You know, that's what you always want when you have this, is just some kind of a battle plan that you can, because when you have a way of fighting back, that makes it easier to sleep at night because you feel like at least you have a chance. You know, it's like from Dumb and Dumber. So you're saying there's a chance. You know, sometimes that's all we're looking for. All right, guys. So it is now 10:05. Again, thank you everybody for being here, and thank you to the moderators for all the channels, for all the work you do. It's very much appreciated. And so we'll see everybody soon. If you want to see me and Nick and Joe Krowski, and I'm not sure who the fourth guest is, check out Court TV tonight. Thanks, guys.